So my name is Courtney Lawler, and I am an assistant professor here at the University of Kentucky College of Law, and I would like to welcome you all here this afternoon for the second annual Forum on Criminal Law Reform in the Commonwealth of Kentucky. Can you all hear me okay in the back? Okay, great. As you all hopefully know by now, the speakers this afternoon will be discussing the status of the death penalty here in Kentucky with specific regard to the ABA Kentucky Death Penalty Assessment Team's report on the administration of the death penalty here. Our afternoon will begin with a presentation by two of the assessment team members, one of them who is the co-chair, Professor Linda Ewald, and also Sarah Turberville, who is joining us from the ABA. We will then hear from Professor Jerry Vito, who will share with us some of the latest social science research on the death penalty here in Kentucky, followed by Professor Marla Sandys, who will focus specifically on capital jurors. We are incredibly fortunate to have the incomparable Steve Bright as our keynote speaker. As many of you know, he is an alum of the law school and the president and senior counsel of the Southern Center for Human Rights. We will close out the afternoon with a tremendous panel of esteemed judges, legislators, cabinet members, professors, and practitioners who will share with us their thoughts on the report, the recommendations, and the presentations that you'll hear this afternoon. It's really quite an amazing lineup of people, and we're thrilled that you could be here to join us. I have a few announcements that I must make on behalf of the KBA. So the handbook you received when you checked in includes materials for today's entire program. There are 4.25 CLE credits available for this program. A Kentucky Attendance Certification Form, Form 3, was provided to you in your seminar handbook when you registered. If you have questions about the form, you may ask a KBA CLE staff member at the registration desk. Lori Alvey, I know, is out there and happy to answer any questions you might have about filling out the forms. If you're a member of another state bar, you can request a copy of the uniform attendance certificate from her as well. At the end of today's session, please turn in your CLE attendance form at the KBA registration desk. And if you have other questions, again, please talk to Lori. We ask that there be no smoking and that all cellular telephones be turned off, or at least on vibrate. Smoking is prohibited in the building, and obviously cell phones can be quite a distraction in the middle of hearing what our speakers have to say. Pursuant to the Kentucky Fire Code, we are asked to point out the exits to you in case of an emergency. So there are obviously two at the back. I feel like I should be an airline attendant. And these should be, or at least that one should be open as well. So if you have any other questions about the CLE components, again, talk to Lori. We are very fortunate here at the University of Kentucky College of Law to have David Brennan as our dean. Dean Brennan is a tax scholar who specializes in the taxation of nonprofit organizations and is regarded as an innovator in the field of nonprofit law. Dean Brennan came to us from the University of Georgia School of Law, as well as the Association of American Law Schools, where he served as the deputy director for 2 years. A Florida native, which causes some tension from time to time when we have SEC football games, Dean Brennan has offered his full support to important criminal justice conferences such as this and to the criminal justice projects pursued by those of us who are faculty members interested in the field. So I hope that you'll please join me in giving Dean Brennan a warm round of applause.
Thank you, Courtney. I want to welcome you to our law school. I am here to really pitch the law school, and I take every opportunity to do that because that's my job as dean. But I especially, though, want to thank some folks who played a key role in pulling this together, not the least of which is, Ed Monahan, who's just been tireless in making sure we had this program scheduled. He actually wanted to do one last year, and we just could not make it happen last year, but he was insistent that we have to do it this year, and here we are. So thank you, Ed and his wonderful staff. They've been on top of every aspect of this as it's been moving forward. And as an example of how great partnerships can work, Ed has been working very closely with members of our staff, both the paid staff and our students. Danny Murphy, who's chair of Commerce Lexington, couldn't be here today. He's been very instrumental in making this event a reality. But we do have other staff members who've helped out. Amanda DeBoard, who's our communications director, and of course Courtney Lawler, who's one of our newest professors here at the law school. I especially want to remark upon the Kentucky Law Journal students. They've just been fabulous in making this happen. This is probably, I'm in my 5th year as dean here, this is probably the 5th or 6th or 7th, I don't remember how many, symposium that we've done in collaboration with the Law Journal, and all of them have been outstanding on a variety of topics. We've done some on tax and nonprofit, we've done some on structural racism, we've done them on lawyering and the public service, so I think that that shows the broad scope in which our journal addresses legal issues of concern to Kentucky. And so thank you. Jessica Beard and Sarah Lawson, I think, are the two kind of co-leaders on this, and I'm sure that every member of the journal staff has been very helpful in making it a reality. Now, about my favorite subject, this law school. UK law is just a fabulous place to educate Kentucky lawyers and even lawyers that go beyond Kentucky. Your keynote speaker today, Stephen Bright, graduated from the law school in 1974, has been on the faculty of Yale Law School for a number of years since that time, has also taught at Harvard and done a few other things in between. So I think that shows the fabulous nature of the legal education you can receive at this law school. Legal education has been facing challenges in the recent past with the downturn in the number of people applying to law school, and UK law has not been immune from those impacts. But I want to emphasize to you that we're still doing an outstanding job in terms of outputs. The two major outputs that you can use to view a law school are job placement and bar passage. For the past 20 years or so, our law school has consistently had job placement numbers in the upper echelon of law schools across the country. Out of the 200 law schools, we're in the top 20 in terms of job placement at around 90+%. This past year, we were 94.5%. The year before, we were 95.6%. That means that within 9 months of graduation, our students are getting jobs in a variety of arenas across the country. Secondly, in terms of bar passage, for the past 20 years, we have been really outpacing almost any law school in the country. This past July, for example, our bar passage rate was 92%. So I think that's a testament to the very hard work that not only the staff do, but that the students do in terms of really immersing themselves into this environment. We are a small law school. We don't profess to be a national law school or compete with some of the law schools across the country on some realms. We pride ourselves in being a law school that's about 400 students and actually trying to get smaller. But we are a small law school that's on a large campus, and so that allows the students to kind of take advantage of some of the things that are offered at a university of 30,000 students, like attending a basketball game every now and then, and even a football game when the mood hits, except for when they're playing certain SEC opponents who we won't name. The last and really one of the key things that I think you should recognize is that the heart of our law school is our faculty. We have outstanding faculty at this place, and let me just give you one example of how outstanding they are. In the past 3 years, we've had 3 of our faculty members' scholarships cited by the U.S. Supreme Court. Most recently, one of our faculty scholarship was cited in that famous healthcare case that you all have probably heard about. And I think that's a mark of distinction for our faculty, in that when the students come here, they are learning from the best and the brightest minds, not only in the Commonwealth of Kentucky, but in the nation. So I want to thank you for being at our law school. Thank you for having the event here. Thank Ed and the Law Journal staff and everyone that's made this possible. And hopefully you'll enjoy your afternoon today and feel reinvigorated about this report and know that there's a bright future ahead. Thank you.
To start us off this afternoon, we have Professor Emeritus Linda Sorensen Ewald, as well as Sarah Turberville. Professor Ewald was a member of the University of Louisville Brandeis School of Law faculty for more than 30 years, where she taught family law, ethics, and professional responsibility, and was an associate dean. In addition to her academic career, Professor Ewald has been active in the larger legal community as well. She was the vice chair and then the chair of the KBA Ethics Committee from 1998 until 2012. She has also been a member of the Kentucky Bar Foundation Board, the Kentucky Judicial Nominating Commission, and the KBA Ethics Commission. Professor Ewald's service to the university, community, and profession has been recognized through a number of awards, including the Kentucky Bar Association Justice Thomas Spain Award, the University of Louisville Lifetime Service Award, the Law Alumni Award, the Jefferson County Women Lawyers Association Award, and the University of Louisville Distinguished Service Award. Most importantly for today's purposes, Professor Ewald also served as the co-chair with Professor Michael Mannheimer of the ABA's Kentucky Death Penalty Assessment Report. Sarah Turberville is the director of the American Bar Association's Death Penalty Moratorium Implementation Project. In this capacity, Ms. Turberville encourages state government leaders and bar associations to undertake detailed examinations of their death penalty systems and presses for reforms to improve fairness and minimize the risk of executing innocent individuals. Ms. Turberville is an adjunct faculty member at the University of Maryland and a former assistant public defender for the state of Maryland. A graduate of Tulane Law School, Ms. Turberville participated in post-Katrina litigation and has worked in The Hague with the International Criminal Tribunal for the former Yugoslavia. Ms. Turberville facilitated the Kentucky assessment, and we're fortunate to have her here with us today. Thank you.
Thank you for that, and I'm going to remain seated as in full recognition of my lesser status as a non-native Kentuckian, who's one of the few that's on the list of panelists today. I too would like to extend my thanks to the University of Kentucky College of Law and the Kentucky Bar Association's Criminal Law section for inviting all of us to be a part of this program. We've spent over 2 years evaluating the Commonwealth's death penalty system, and I'm thrilled to see the report's findings and recommendations discussed here and hopefully implemented. I'd also like to thank the 8 Kentucky assessment team members who spent countless hours on the phone and in-person meetings and on email in their adoption of the Commonwealth's report on the death penalty. This report truly is their own, and there's no way this could have gotten off the ground without the effort of these 8 volunteer lawyers. My purpose is to give you an understanding of the project's method of assessment in Kentucky as well as in all the jurisdictions that have been assessed by the project, and perhaps place some of the Kentucky findings in context by looking at other states that we've also examined through this process. First, I'd like to give you a little bit of background about the ABA's work on the death penalty. Since Gregg v. Georgia, over the past 30 to almost 40 years, the ABA has been increasingly concerned about the extent to which death penalty states are able to ensure fairness and accuracy in their death penalty systems. To that end, the association has adopted a number of policies beginning as early as 1979 with, in that instance, seeking to improve the provision of counsel afforded in death penalty cases. The association has also adopted policies to encourage thorough judicial review on the merits of capital convictions and death sentences. In 1983, the association adopted a policy supporting the exclusion of juveniles from the death penalty many, many years before the Supreme Court saw the light of day in Roper v. Simmons later in 2005. The association also took up a policy supporting the exclusion of people with mental retardation from the death penalty in 1989, and as recently as 2006 adopted a policy supporting the exclusion of people with severe mental illness from execution. The ABA has also been, on the heels of McCleskey v. Kemp, concerned about racial disparity in the application of capital punishment in the modern death penalty era, and to that end adopted a policy not only supporting the exclusion or the elimination of racial disparity in death penalty cases, but also supporting states' enactment of a Racial Justice Act to try to ameliorate the possible disparity that might enter into the equation whenever a capital conviction is sought. However, in the 1990s, what we saw is rather than states and the federal government seeking to adopt better practices, they were moving in the opposite direction. As many of you probably know, 1999 there were more executions in the United States than at any other time after Furman v. Georgia, and states were moving, and the federal government were moving toward closing off review of death penalty cases rather than trying to provide greater access to the courts for people facing execution. All of this came to a head, at least in the ABA's view, in 1996 when Congress enacted something called the Anti-Terrorism and Effective Death Penalty Act, sometimes called AEDPA. And what AEDPA did was dramatically curtail the ability of the federal courts to review a death sentence imposed by a state court on the merits. And most of these restrictions that I've talked about remain in place today. At that same time, Congress defunded several of the post-conviction centers for litigation that were doing a very good job of representing people who were under a death sentence. And at that time, the ABA said enough is enough. In order to take the pressure off the system, we support a suspension of executions until states evaluate what is happening in their capital punishment system and fix whatever flaws may have come to light through that evaluation process. So a couple years later, given the level of interest in the issue, the ABA established my project, which has actually recently been renamed the ABA Death Penalty Due Process Review Project, to support its mission of trying to seek better fairness and accuracy in capital cases. Our mission is to educate decision makers, the bar, and the public on systemic problems and to encourage capital jurisdictions to take appropriate actions to remedy whatever problems may exist and wherever they may exist. And our main mechanism through which we have done this is through our state assessments on the death penalty. Kentucky was our 9th of 12 states evaluated through this process. And in total, these states represent about 65% of the executions that have taken place in the U.S. in the modern death penalty era. The other states are Alabama, Arizona, Georgia, Florida, Indiana, Missouri, Ohio, Pennsylvania, Tennessee, and we most recently released reports on Texas and Virginia in September of this year. So the framework for each one of these assessments is a series of benchmarks or protocols that have been set out by the ABA. And they don't cover all aspects of the capital punishment system. For example, there's a lot of attention these days to questions about method of execution and lethal injection. That's, for example, not an issue covered by one of these reports. But they do cover a number of areas from arrest to execution, including, for example, law enforcement practices during the investigation of a capital case, the provision of defense services, the efficacy and transparency of clemency proceedings, and the treatment of special populations in the capital punishment system, such as people with mental retardation and mental illness, as well as racial and ethnic minorities. The first task in undertaking the assessments is, of course, to select the jurisdiction in which to conduct an assessment. And one of the reasons that the project selected Kentucky is that it was a state that appeared to have a few mechanisms in place that would comport with the ABA benchmarks, most notably an independent capital defender system. And at the time, Kentucky was the only state in the nation that had ever adopted a Racial Justice Act. One of the other reasons we selected Kentucky was for geographic diversity. And then finally, comparatively speaking, Kentucky has had fewer death sentences and certainly fewer executions than other jurisdictions that we have assessed. And what that enabled the team to do was to evaluate every death sentence that had been imposed in the Commonwealth since Kentucky reinstated the death penalty in 1976 or 1977. I'll have to check that. This is not something we were able to do in any other jurisdiction that we evaluated. So then it was up to our state-based team of lawyers to conduct the assessment. And as the ABA takes no position on the death penalty per se, neither do our state teams. Instead, their guiding principle was only that as long as the state has the death penalty, it must ensure fairness, due process, and it must minimize the risk of executing an innocent person. There was no litmus test for involvement in this project, except that our team members be willing to evaluate the state in light of these 90-plus ABA benchmarks or protocols that I was talking about. So then we conducted the assessment. We collected legal and factual research relative to the 90-plus benchmarks to get a current and accurate picture of the fairness of the Commonwealth's death penalty system. We obtained information from the Office of the Governor, the Kentucky Court of Justice, many agencies involved in Kentucky law enforcement, the state crime laboratory and medical examiners' offices, and the public defender, the DPA, was also quite helpful as well in providing information. Exhaustive legal research comprises a substantial amount of the information contained in the, I think, 500-plus page report, but there are also areas that the team wanted to review but could not due to the lack of access to the data needed in order to make an evaluation of what was happening in a particular area of concern. So the assessment describes how the Commonwealth's death penalty functions in both design and practice, and areas where the Commonwealth has made improvements to its capital punishment system over the last several years. However, the crux of the report is focused on where problems remain, and for that I'll turn it over to Linda Ewald to describe in some greater detail.
Hey, Sarah. What happened to that?
Do you want to hold on to this?
Yeah. There we go. Okay. Okay, well, I'm going to start by, I have to stand behind a podium. I did it for 35 years, and somehow I just can't really say anything unless I'm standing up. So, and I'm not originally from here, so it has nothing to do with my origin or anything else. I, too, want to thank Dean Brennan and Professor Lawler and the KBA for hosting this program here. I think Dean Brennan used the word reinvigorate, and I want to emphasize that because gatherings like this are really critical to kind of getting the word out and reacquainting people and reinforcing some of the things that we're going to talk about here today. As we'll see, there are many, many players in this whole process, and we need to get to all of them. And we're counting on people like you in the audience here today to help us do that. I have to say something about this team. It's the most incredible group of lawyers I've ever had the privilege of working with. Mike Manheimer from Chase and I co-chaired this. This was a work of very dedicated lawyers and judges in the Commonwealth. And I just want to mention that Justice Keller and Justice Johnstone, both of whom are here today, were on the committee, on the team. Mike Bowling and Hap Moore, practicing lawyers. Marcia Milby Ridings, who was a former KBA president, was on this group. And last but not least, Professor Allison Conley from the University of Kentucky College of Law really kept us moving and kept us on track throughout this whole process. In addition, we had some remarkable support in Washington through Sarah and several legal researchers, really all dedicated lawyers who care passionately about this subject and work tirelessly to get this 500-some-odd page report out. The work we did was really small in comparison to what they did at many levels. We did spend a lot of hours. We did talk to a lot of people. This is not something where a bunch of us went into a room for a couple of days and cranked this thing out. This was a 2-year process, and we took this work very seriously. And it's a piece of work that I'm very proud of, and I think every member of the team is proud of. As Sarah said, our goal was not to debate the death penalty. My expectation is that just like in this room here today. The views of the members of the team varied considerably about the death penalty itself, but our goal was to see that as long as Kentucky does have the death penalty, it's administered in a fair and accurate way. We were also very fortunate, and I think this is not necessarily what happened in some other jurisdictions. For the most part, the folks that we worked with, the people from whom we sought information, were incredibly helpful to us, and we really are grateful to that. I think the credibility of the report is increased as a consequence of really the great cooperation we got from the Justice Cabinet and DPA and a lot of other folks. Our initial goal was to review these 92 protocols that the ABA had determined through a fairly extensive process were critical to a fair and accurate system. And we started that process, and we started on the mental health ones, as I recall, and everyone thought, oh gosh, I hope the next ones aren't as hard as this one was. But we went through this process of reviewing these protocols, and it was only after we finished looking at how we operate in this jurisdiction that we began to think about the kinds of things that needed to be changed and the kind of recommendations we as a team needed to make through this report. I would note that Kentucky really has, as Sarah said, been a leader in a number of areas. The statewide public defender is obviously one of them, whereby we have somebody to represent every capital defendant and every death row inmate who's indigent. And when you look at other states and you go to conferences and you hear about what's going on in other jurisdictions, you realize how far ahead we are on that count. Kentucky has post-conviction DNA testing provided for, not true in all jurisdictions. And of course, Sarah mentioned the Racial Justice Act. But despite these really good things that we have in this state, there are too many areas in which the team ultimately determined that Kentucky's procedures fall short and fail to provide the necessary safeguards to assure that the system is fair and accurate. The areas in which the team unanimously agreed that we needed the most reform, and you'll be grateful to know that I'm not going to tell you talk about all of the 92 protocols or the recommendations that went with each of those 92 protocols, but roughly they fall in these categories that we have up here, and similar material is in what you have before you. But one of the things we discovered very early on was that Kentucky had a very high error rate in death penalty cases. Since the reinstatement of the death penalty in 1976, 50 of 78 people who'd been sentenced to death have had their death sentences overturned on appeal due to serious constitutional errors or misconduct that occurred during the trial. That's over 60%. 60%. Imagine the resources that could be saved if we could reduce that reversal rate by getting it right the first time. Adoptions of a lot of the team's recommendations, I think, could go a long way in reducing the number of errors that occur at the trial level. We talked about DNA testing post-conviction, and that's a good thing, but we don't have any rule in this jurisdiction that requires that evidence be retained as long as the defendant remains incarcerated. So we have this right to post-conviction DNA testing, for example, but that's of little value to us, I guess, if the evidence has been lost or destroyed, which has happened in a number of cases. We also worry about inadequate protection against wrongful conviction. If you look at the nationwide statistics, you'll find that two of the leading causes of wrongful convictions nationally are false eyewitness identification and false confessions. Kentucky has no uniform standard on how eyewitness identifications are to take place or how interrogations are to take place. We made a number of suggestions in that regard in terms of how law enforcement could change their practices to reduce the risks associated with eyewitness identification and interrogational confessions, but court rules might also provide some assistance so that jurors better understood some of the risks in relying upon this kind of evidence. We also discovered, as many of you well know, the inconsistent application of the death penalty in Kentucky. There's no mechanism in place to guide prosecutors in making charging decisions, and there's no oversight to the exercise of prosecutorial discretion. And the practices vary dramatically across this state. In some jurisdictions, it's the practice to charge every capital eligible case. In other jurisdictions, there's rarely a death penalty sought. And so whether or not when one is arrested on a serious offense, he or she is going to be charged with the death penalty, oftentimes is merely a function of where he or she lives, something that we found quite disturbing. Jury confusion was another area where some empirical research that we had caused us to be pretty concerned. And a survey of Kentucky jurors serving in capital cases, and now these are Kentucky jurors who have served on capital cases, demonstrated that the jurors failed to understand the sentencing guidelines before deciding whether the defendant should be sentenced to death. Interviews with Kentucky jurors in capital cases revealed 46% failed to understand that they could consider mitigation evidence in sentencing. 62% didn't understand that they need not find mitigation beyond a reasonable doubt. And 84% didn't understand that they didn't have to be unanimous on the finding of mitigation. We find it pretty upsetting that jurors essentially didn't know what they were supposed to consider in deciding whether to impose a death sentence or not. Our public defender, we're very proud of the Jefferson County Public Defender Department of Public Advocacy and so forth. They do a great job, but they're extraordinarily underpaid and understaffed or overworked, whatever way you want to look at it. Their salaries are 31% below comparable salaries in other jurisdictions. Their workloads far exceed national standards. And private attorneys who are hired principally to do contract work, or conflict work, are paid far less than other contract lawyers hired by the Commonwealth of Kentucky. So you can be a contract lawyer hired to go out and do something with regard to environmental protection or whatever on the civil side, and those lawyers are paid much more than the conflicts counsel are paid by the Commonwealth. We also found an alarming group of folks who've probably been on death row for some period of time. In at least 10 of the 78 cases that we looked at of folks who'd been sentenced to death since the reintroduction of the death penalty, 10 of the 78 had been represented by a lawyer who was later disbarred. Now, those were not DPA lawyers. I point out most of these cases arose in the years when we had appointments, when we had volunteers and court appointment more than we have today. But nevertheless, we've got folks sitting on death row who were represented by some pretty unqualified lawyers, I'm afraid. Sarah talked about adequate protection for the mentally disabled. One of the things that we found quite disturbing was that Kentucky, in defining mental retardation or intellectual impairment, the standards they use don't in any way comport with contemporary scientific methodology. So that's pretty troubling. And the last thing Sarah talked about was the lack of data. And we found many instances in which, in checking the boxes, whether Kentucky complies or doesn't comply or partially complies, we just had to say, we're not really sure. And the reason we weren't sure was not because we didn't work hard, but because Kentucky just doesn't collect the data in a centralized location so that we can do a comprehensive assessment of this. I mean, it impaired our ability to do our work, but the areas that we found most concerning were that the data relative to death-eligible cases just didn't seem to be available so that we could assess, or so that a court could properly assess issues with regard to proportionality. We've got the Racial Justice Act, but we don't have data that we can rely upon in order to determine whether the Racial Justice Act is functioning really the way it's supposed to. At the end of the day, we found that the Commonwealth was not in compliance on 25 of the 92 protocols that we looked at. We found that they were only in partial compliance on another 40. So of all of the protocols, all of the 92 protocols, we were either not in compliance or only in partial compliance on 71%. And then we have that whole category that we couldn't tell. So there are just lots of areas in which we have a lot of room to do a lot of work in order to bring this system that we have in this state into full compliance and have a system that's fair and equitable to all. At the end of the day, having looked at all of these protocols, this team recommended that Kentucky suspend executions until such time as we can bring the state into compliance. Sarah's got some thoughts about how we look compared to other states, and she's going to talk about that and talk about a survey that we did.
Thanks, Linda. I did just want to maybe provide a little bit of context for some of these findings. And, to be sure, some of the issues that Linda described were universally problematic in every jurisdiction that we examined. But some of them, I think, are problems that are unique to Kentucky, and I'll just give you a couple examples of that. This part of the benefit of examining the system from arrest to execution is that you can determine where there are positive, there are sound procedures in place, but then also can see where maybe some of those are undermined by more problematic procedures that are in place in other areas. And one of the examples to that, I think, is with respect to the lack of access to evidence or lack of discovery in post-conviction proceedings in Kentucky. And post-conviction is the first opportunity for somebody who's under a death sentence, or anybody, but in this context, under a death sentence, to raise issues that are outside the trial record, issues of constitutional magnitude, such as, for example, that a prosecutor withheld exculpatory evidence under Brady v. Maryland. However, in Kentucky, because there is no right to discovery, and an inmate would need to show, in order to get an evidentiary hearing in post-conviction, that there was a constitutional violation, he's essentially placed in a catch-22 where he can't get access to the very evidence that would indicate that there was a constitutional violation in order to get an evidentiary hearing in the first instance. And I think Kentucky also explicitly prohibits the use of the Open Records Act to be able to obtain that kind of evidentiary material, and that's also nearly unique to the Commonwealth. Another area of concern in post-conviction is that while Kentucky does permit an inmate to file a petition within 3 years after their death sentence has become final, that time span can be dramatically curtailed by the setting of an execution date before the 3 years elapses. So what was 3 years in a death penalty case can be all of a sudden 360 days, whereas that doesn't happen to someone who's not under a death sentence. Then finally, one note I would make about the treatment of about Kentucky realizing the Atkins v. Virginia decision. Kentucky is one of the few states as well that sets a bright line maximum IQ of 70 to determine whether or not somebody has mental retardation, which does not comport with the modern scientific understanding of mental retardation, or what's now called intellectual disability. So this means that even though it is unconstitutional to execute someone with MR, because of this bright line IQ, those individuals could very well be executed in the Commonwealth. So on a closing note, I would just suggest that proceeding at utmost caution when a life is at stake is something that we've found resonates with the vast majority of Kentuckians, and that political decision makers wouldn't lose their jobs in supporting the reforms that have been suggested by the assessment team. And a poll conducted that we conducted at the end of 2011 at the release of the assessment report revealed that the majority of Kentuckians, regardless of political party, gender, geography, would support a suspension of executions to allow for there to be space for discussion and implementation of the reforms that have been recommended. So with that, I turn it back over to Professor Lawler and look forward to the discussion that we'll be having today.
Thank you both for that. It's very interesting and very informative. Next, we want to turn to Professor Jerry Vito, who is a distinguished university scholar and professor and vice chair of the Department of Justice Administration at the University of Louisville. He is also a faculty member at the Administrative Officers course at the Southern Police Institute. A prolific scholar, Professor Vito has authored 9 textbooks, more than 65 professional journal articles, and more than 40 research reports on various issues related to the criminal justice field. He is a president and fellow of the Academy of Criminal Justice Sciences and the recipient of numerous awards, including the Educator of the Year Award from the Southern Criminal Justice Association and the President's Distinguished Faculty Award for Excellence in Research, among others. Professor Vito has made presentations to the American Correctional Association and the Kentucky Bar Association, and we are pleased to have him here today to share his latest research with us. Please join me in welcoming Professor Vito.
Well, as you might guess, I too am not from these parts, and I've got this thing up here that I put on the UK campus, and the last time I was in a room like this, I think I got probation, so I'm gonna stand here where I can duck. Well, my collaborator is Dr. Higgins here today, and the doctoral student that both of us know pretty well that helped us work on this. We put this together finally. In terms of Kentucky, as was mentioned, it was reinstated capital punishment in 1976. And this reestablishment took place despite a background of racial bias in the imposition of the death penalty in both the country and the Commonwealth. Previous studies of capital sentencing in Kentucky and other states revealed that prosecutors were likely to seek the death penalty in cases involving white victims, especially cases where blacks were charged with killing whites, multiple victims, more than one aggravator, a concurrent felony aggravator, and female victims. So in this particular study, we try to build on what we've done before, in both in Kentucky and in these other states. And we got data from, thank God, the Kentucky Department of Public Advocacy collected these data, and we owe them a great debt. And we examined death-eligible cases for the years 2000 through 2010, and it was 359 cases. The cases from Jefferson County were excluded from this portion of the analysis because, as was mentioned for a time, in Jefferson County, the policy was to seek the death penalty whenever aggravator was present. And we did look at those cases. We did a separate analysis on that and published that. But for this portion, they're excluded. The prosecutorial decision to seek the death penalty was influenced by the presence of a female victim. That was our first finding. The multivariate analysis determined the death penalty in Kentucky was sought 3 2.17 times, or 217% more likely when the victim was female. Cases featuring a black defendant and a white victim were 50% less likely to result in a plea. Now, we don't know anything more about the plea, what was done or what was offered, or anything like that. It's just the result, okay? Then the cases featuring other defendant-victim racial combinations. Cases featuring black offenders who were charged with killing white victims and were not pled were more likely to result in a sentence of life without parole. So the most serious penalty available absent the death penalty. The fact that race of the offender with or without the presence of a white victim was not related to the decision to seek the death penalty may be the result of the passage of the Kentucky Racial Justice Act, but as was said previously too, we don't really know, but it did happen prior to this period. In terms of the statewide disposition, when we put the Jefferson County cases back in and just look at how they were disposed of, the breakdown goes like this. Death penalty sought in 70% of the death-eligible cases. Of these cases, the majority resulted in a guilty plea, 69%. Among these cases, almost one-third resulted in a sentence of life without parole. One death sentence was levied at this stage, in the ones that were pled. Among the cases where the death penalty was sought, over 30% went to the jury. Juries levied a sentence of years in 34% of these cases and a sentence of life without parole in over 23% of the cases. 7 cases resulted in a death sentence. Overall, among the cases where the death penalty was sought, almost 30% resulted in a sentence of life without parole, while the sentence of death occurred just about 2% of the time. Now, what are our conclusions? Well, like we said, race is still a factor in at least one stage of the capital sentencing process. The decision to accept the plea was influenced by race of offender and race of the victim. Cases with black offenders charged with killing a white victim were much less likely to result in a plea. There are some limitations to these findings, however. First of all, again, the decision-making portion excludes Jefferson County, so it's not the entire state. The research findings of that part of the study apply to the rest of Kentucky. There is no jurisdictional pattern. I mean, sometimes when these studies have been done, they found like one county was the source of the problem. We didn't find anything like that. It's a system-wide pattern for the whole state. So they're not attributable to one county, one prosecutor, one defense attorney, one jury. You know, it's a statewide pattern. They're also not the result of one particular defendant being discriminated against. But they do reflect the results of the entire capital sentencing process in Kentucky and should be illuminating to those officials responsible for the operation of it in its entirety. When the statewide disposition of cases is considered, it's obvious that the juries have a marked preference for the sentence of life without parole. LWOP was levied by the jury, again, in like 24% of the cases, and they sentenced the defendant to death less than 6% of the time. Given the time and effort spent on these cases, these findings question whether the capital sentencing process is a wise use of resources by the Kentucky courts. And despite legal requirements, Kentucky fails to collect data to assess the factors that influence the seeking and imposition of the death penalty, as was mentioned in the report. And Dr. Higgins and I have been talking about this because among our other research that we've done has been traffic stops by the police. And police departments, just about nationwide, were required to collect data on traffic stops because they were being accused of racial discrimination. And I'm sure that they weren't happy about this. In fact, I know it because my students in the Southern Police Institute complain about it all the time. But they did it. And we analyzed it. In fact, we advised Louisville in particular on what to collect. And they collected data on over 80 variables, and we had thousands of cases. So I guess my message here is, if the police can do it, I think it can be done for 600-something capital cases. So we can at least examine what's going on. So thank you.
We're going to have a 5-minute stretch break before we go on to the next one.
Okay, that's fine. Also, I think it's not being we have the signs over there. Okay. Okay. Yeah, right. I might be. Or not. I get nervous. I know. I get nervous when I'm a little bit of. Absolutely. I know I did the same thing. I don't know. That's right. She's like Ewald. No, I asked her. Yeah. Because I was like, not Professor, Miss Turberville, because I was like, how do you say your partner's name? Yeah. I said it, I went to go say it the first time, and as I said it, I was like, I don't think I said that right. So then that's why when you were setting up, I was like, yeah. Well, I just, because she mentioned, correct, because she mentioned some of my findings on prison. So I want to skip through them pretty quickly and then go back to her. Yeah, just say as she mentioned, but I wanted to make sure I knew that I wanted to say right. So, that's fun. So, this will let you go no matter where you point it. You should be able to point it anywhere and click forward with this or click back on it. And then you can point with the red button. Yeah, so that's what my instructions tell me is that I'm going to call for 5 minutes to break. It's like, okay. She has it's funny to have like a whole set of instructions about being a moderator. Yeah. She's like, your moderator instructions are in the packet. I was like, oh, okay. Good to know. And I wanted to tell you, during the first presentation, I guess during Professor B, they were having trouble hearing in the back. Okay, so you want me to project? Oh, okay. I'm sure you will since you're a professor. That's right. And I realized that since I'm going to be right there, I might keep that. I don't know if it's. I just brought it just in case, but it's the same over there. People see it less, but either way, you have that little thing in front of it, so you're good. How far is the drive? We drove this morning. It's 3.5 hours or so. That's not too bad. Yeah. Is it easy? Yeah, but it was great time because there was no traffic at all. So wait till like right after 9 o'clock today.
I've got a little water here.
For you? Okay.
I wanted to introduce myself to you. I used to practice in Atlanta.
I know. You used to be a PDS.
I did.
Yes, my goodness.
I know. I was like, I actually
I'm
have
delighted
a
to
chance to meet
see
you.
that you can also is hiring people.
Me too.
And your background. That's
Me too.
great. How
3 months. I mean, technically
Oh,
I
really?
started
Oh,
in
you
July.
just
I'm brand new.
Oh,
Yeah.
just started. Well, wow.
Yeah, thank you. I'm excited
So
to
are
be
you
here.
filling the very big shoes from Bob Lawson?
People keep saying that. I'm like, you need to stop saying that. Those are humongous shoes to
Right,
fill,
right,
you know?
they are.
Yeah, I mean, I would love it if one day I could fill those shoes, but I think, that's how you have to be
Right.
seen. So.
But you're teaching the criminal law course?
Yep, I'm doing all the stuff, yeah. It's been great. It's been really wonderful. And I didn't realize I think of you as an Atlanta person. I didn't realize you actually went here and live here and, all of that.
Right. I started out the
Yeah.
We used to have the office somewhere else.
Up here. It's fantastic. That's awesome. Well, yeah, I will look forward to hearing it. All right. All right, if we could start heading back in, that would be great. You're like, really, no rush. You're like I am. Yeah, I know I do this all the time for a living, but really. It's not my favorite. I hear you.
I will take this.
I was a practical child here for 9 years. Only one time did I ever have to testify. I was in trouble. I was like
not to be argumentative. That wasn't exactly what I was saying. Right? Like, you're
And
like,
I'm just not comfortable in that context, and I don't think quick enough on my feet.
No, I totally hear you.
It seems like an easy.
Well, that's what I'm saying. No Q&A.
And Ed told me there are no questions.
That's right.
So I'm like, you're good, easy, right?
All right. If we can start sitting back down, that would be great so we can keep moving. I wish I hadn't asked for the 5-minute break. I figured we had extra time. It'd be nice. Good. All right. Our next speaker is Professor Marla Sandys. Professor Sandys is an associate professor in Indiana University's Department of Criminal Justice in Bloomington. She received her PhD in social psychology here at the University of Kentucky and is an original member of the Capital Jury Project, which is a consortium of researchers funded by the National Science Foundation. Professor Sandys' work focuses on jurors and the decisions that they make in capital cases. She recently received a grant to study jurors' perceptions of mental illness as it relates to the death penalty in Indiana. And we welcome Professor Sandys back to Lexington.
Thank you. It really is a pleasure to be back. What isn't quite a pleasure is to walk around and realize I don't recognize anything. It's been that long, and I'm getting a little bit lost. But I'm hopeful that after all of this, I'm going to walk around and try to find the psych building. And if you see somebody walking in circles, if you'll help, I would appreciate it. It was a while back that Ed Monahan contacted me and asked if I would be willing to come and speak. And when he sent me the invitation, he put it as an attachment, and I was out of town, and for whatever reason I couldn't open the attachment, and my comment was, I can't imagine I would ever say no, but it would be helpful if I could see what it was that I was agreeing to do. And when I opened it up and I found out that this is exactly what he was asking for, I immediately said yes. And I said yes because I feel as though there are many people I owe a thanks to for having really contributed to my education and my work in death penalty cases. But perhaps more than that, I said yes because I think these are the kinds of forums that are needed. As an academic, sometimes you feel as though you write an article and nobody reads it. And so when you're invited to have this kind of opportunity to speak to people who might actually be able to do something with your findings, it's a wonderful opportunity. And so for that, I thank you. My talk today, I was asked if I would talk specifically on what capital jurors misunderstand. And so we're going to see, whoops, there you see already. And what I'm going to talk about is primarily, although I'll talk about some other research as well, but it's to talk about the Capital Jury Project. And the findings were also already referenced a little bit earlier today, which is always nice. And the project, the Capital Jury Project, was funded by the National Science Foundation. In fact, it's been funded on 3 separate occasions by the National Science Foundation. There's a total sample of, as I've put up there, 1,198 jurors across the country from 353 trials across 14 separate states. Kentucky was one of those states, and I was lucky enough to be the investigator responsible for overseeing the project here in Kentucky. The data from this portion of the project consists of 113 interviews, and those interviews are face-to-face interviews that last, on average, 3.5 to 4 hours with the jurors. These are jurors who have served on capital cases, both death and life. As you can see in Kentucky, we sort of had it evenly split. And we asked the jurors a whole host of questions from pretrial, guilt phase, penalty phase, post-trial effects, and the like, including instructions. And so, as I said, I'm going to talk about the instructions and things that jurors understand and don't. First, though, I thought it might be helpful for you to realize that instructions actually do matter. oftentimes he thinks jurors might just say, oh, well, we sort of have an intuitive sense about how we're supposed to make these decisions. The instructions by the judges, yeah, they're there, but we're not really following them. And what you find is that when we ask them specifically, if you say they had little or no influence, you can see that 48 said, no, that's not the case at all. But they also go on and slightly higher, more than 50%, to talk about how confusing those instructions are. And we asked in a variety of different ways, but one of the questions was, did the jury stop to ask the judge for further explanation of the law or clarification? And you can see that they do ask quite often. What happens? Why are they confused? And what are the areas in which the jurors become confused? And so a couple of the questions, before we get into the sentencing specifics, I thought you might be interested in knowing how it manifests in other ways as well. So one of the questions is, after hearing the judge's instructions, did you believe that the law required you to impose a death sentence if the evidence proved that the defendant's conduct was heinous, vile, or depraved? And you're saying 41.6% said yes, that they thought that the law required them to vote for death under those circumstances. Similarly, same basic finding if they found that the defendant would be dangerous in the future. And so jurors are operating under that misperception that death is required under certain circumstances. And just so you don't think it's all going to be numbers, I thought I'd put in a couple of quotes from the actual jurors. So this was one of the jurors saying, it was in the outline, if we found the defendant guilty, we had to go by Kentucky state law. If we found him guilty on certain counts, and we found him guilty of capital murder, and we had to weigh some other things too, but, we had to give him capital punishment by state law. So they're clearly misunderstanding state law. Another way in which the misunderstandings occur is when you ask them how much time they think somebody not sentenced to death actually serves before being released. And, we had several jurors who talked about, who said life and the like, but both the median, which is the midpoint, the mode, the most frequent, was 10 years. That the jurors thought that somebody not sentenced to death in this state would be released in 10 years. And again, I'll read through some of the quotes. In terms of talking about parole, the judge didn't explain what life meant. He told us later that he would be eligible for parole in 10 years. He enumerated the kinds of punishments. He explained what they all meant, for instance, and he said either the judge said it or someone else did. If you just give him life, parole would be in 7 to 10 years. We knew when parole would occur. Well, there wasn't a whole lot of instructions. We had to take each count, and it was in writing. If we found him guilty of each individual count, okay, then it was written there, how many years, what we could give him, years, life sentence, or whatever. And we'd sent a question to the judge about how many years we could give him, and he came back and said, read your instructions. So at that point, our concern was, well, we definitely don't want the dude on the street no more, so we gave him 95 on each count. And so, again, clearly parole is a major consideration, and what's happening is that jurors are anticipating that people are going to be released substantially earlier than they would ever even be eligible for parole in many of these situations. Another example, a big question was how long before parole, and we weren't given that answer, bothered several jurors. If we give him 300 years, how long will he serve? That was a big question. What was difficult and what we were not allowed to know was, regardless of the sentence, what amount of time could the defendant spend before parole? And we were not given that information. And this is a really long quote, but I think it really talks quite eloquently, actually, about some of the difficulties that the jurors face. And they talk about how the law, we weren't allowed to know, but some of us already knew it, and that was life with parole was in 12 years. If given life in prison, that was the main factor. If we could give him life and he would really be capped, that, he would have no chance of parole, that's what we'd go for. But some of us knew of that law of 12 years and said, would you feel comfortable if you knew he was going to get paroled in 12 years? Would you want it on your conscience if he got out and carried out some of those threats that he made and he killed somebody else? Would you want it on your conscience and know that you helped him to get out to do that? And undoubtedly, we all said no. We wouldn't want that on ourselves. So that was the main factor that made us make the death decision. They didn't tell us that life in prison meant parole in 12 years. We knew there had to be some reason that the Commonwealth attorney was begging us to bring back the death sentence. We knew from the tone of his voice and his closing arguments. We sensed that he was trying to tell us something that he couldn't say. And so those are sort of the background of ways in which the jurors are confused about the instructions. And some of these findings now are the ones that have already been referenced, so I'm not going to spend a whole lot of time talking about them specifically. But I think it's important to note that our jurors, these jurors from Kentucky, really did not understand mitigation. Did not understand the rules and regulations regarding mitigation, and they were much more consistent and much more correct and on target when looking at aggravators. In particular, as you can see here, they really don't understand, what the proof is, standard of proof is for mitigators. You can see that for aggravators, and it's not that surprising to me that you see proof beyond a reasonable doubt so high, because that's what jurors come in expecting. They don't come in as blank slates. They come in hearing about media, learning about, other kinds of cases that they've heard, watching TV, and they come in and they expect that it's going to be, a case of, you have to be proof beyond a reasonable doubt, and that it has to be unanimous. And what you find is that they still believe that it has to be unanimous when you're talking about mitigation. And then here, just also to show that the jurors don't necessarily understand and recognize that they can consider anything in mitigation. And so what I thought I would do a little bit is to go through excerpts, and granted, I don't have the entire set, but I will say that Cooper's is on my desk, and I sent a couple of emails recently going, I am so confused, especially by your case notes on this, and bare bones doesn't sort of quite get it for me, because I was so confused by your instructions in certain places. And so I pulled out certain, the main areas of the instructions. So for aggravation, it says, in fixing sentence for the defendant, you shall consider the following aggravating circumstances, which you may believe. Now, first of all, I don't know who you is. I don't know if it's you individually. I don't know if it's you, the jury. When you say may believe, does that mean I have a choice? I don't have to believe it beyond a reasonable doubt. It's not stated explicitly. When you look at mitigation, it's the same situation. You shall consider. Now, all of a sudden, you believe to be true. What is that standard? What is the burden of proof there? It's not stated explicitly, but here I have to believe. You believe to be true, and previously made believe. And here, in your catch-all category, it says any other circumstance or circumstances that you, the jury, deem to have mitigating value. So this is the first time that I see you, the jury, is included. So all of a sudden I'm wondering, does that mean that to consider anything beyond your statutory mitigators, it has to be the jury has to agree? Is that what they're thinking? Or do they now take it that the jury has to agree with all aspects of anything related to mitigation? And then at the end it says, you shall consider also those aspects of the defendant's character and those facts and circumstances of the particular offense at which you have found him guilty, which I worry suggests to me that it might be a nexus to the crime sort of message to the jurors, which he's offered evidence in mitigation. Being candid, I'm not sure that mitigation has ever actually been defined here. And then what I thought I would do is, and I'm a little reluctant to go over these just because I do not want to be suggesting that these are model instructions that have no issues. But there are other jurisdictions where they have stated quite explicitly trying to address some of these issues that we know where jurors have this misunderstanding. So in Florida, a mitigating circumstance need not be proved beyond a reasonable doubt by the defendant. They're told explicitly it does not have to be proved beyond a reasonable doubt. Idaho, a mitigating factor is any factor, circumstance relating to the crime or the defendant's state of mind or condition at the time of the crime or to his or her character, background, or record that tends to suggest that a sentence other than death should be imposed. So at least it's telling you what it is. Indiana, mitigating circumstances are different than aggravating circumstances in a number of ways, and they go through a variety. But second, you're finding that any mitigating circumstance exists does not have to be unanimous. Each juror must consider and weigh any mitigating facts he or she finds to exist without regard to whether other jurors agree with that determination. So there are attempts in other jurisdictions to deal with some of these issues where we know that jurors have confusion. The other thing that I thought I would do, anybody who's been on a university campus and does research knows that when you submit any materials for human subjects approval, I'm seeing smiling here, they recognize this. You end up having to submit materials, and they say you have to provide the grade level at which this is, because you have to make sure that everybody can read your materials. And so I thought it might be interesting to look at what the grade level is for your statute. You're reading the instructions. And here are direct quotes, and this comes from Word. Okay, this is what we have to do it through Word. So this is direct quotes, and they give you the whole formula there, and it's based on average sentence length and average number of syllables per word and all that. And they give you two separate kinds of data. One is the reading ease, and as you can see, they say that it ranges from, 100, it's a 100-point scale, and you should try to get something between 60 and 70. And the next is our standard grade levels, and they say you should aim for a score of approximately 7 to 8. I thought you might want to see the education levels for Kentucky, just keep it in perspective. So you have, almost 82% with high school graduates and 20% that are bachelor's degree or more. And so what I did was I took the instructions, the readability instructions, and did your introductory one. And so that you can see it, your reading ease on that is 40, on a scale up to 100, that should be between 60 and 70, and the grade level is basically a college grad at 15.9. Mitigating circumstances, again, the reading ease is at about 42. And the Kincaid grade level is now, you're at a sophomore level. Aggravating circumstances is reading ease is even worse at 30, but the grade level is at 12.6, so basically a high school grad. And this next one, which guides jurors on how they're supposed to decide their sentences, the reading ease is 15.7, and the grade level is 23.8. And I was joking that my joke, they always say you should have some humor, is no wonder I can't understand it. I only have 20 years of education. So, which is true. I don't understand it. But I digress. Anyway, so I put that just as a background to give you an idea that it's not, you all speak a slightly different language. And that we, non-lawyers, need a little bit of help. And the good news is that there's been quite a bit of mock jury research that has actually tried to improve comprehension. It's not that difficult to do, okay? And mock jury research, and we can have discussions about the strengths and weaknesses of a variety of different methodological approaches, but oftentimes, you can do mock jury research where you're either using college students or people who've been called for jury duty. And what you can do here that is pretty straightforward is to hire a linguist, hire somebody else who can come in and work with judges, prosecutors, defense attorneys, former jurors, all come together and try to come up with instructions that meet the criteria, that are legally accurate. I would not feel comfortable writing an instruction by myself because I'm still not quite convinced that I would know exactly all the legal, specifications that need to be in those instructions. But if you have representatives from all parties together and you work with a linguist who can help you, which is what many of these studies here have done, you can see that you can in fact improve comprehension. Sometimes they've done it very well, meaning that they've improved comprehension from 20% up to 80%, and other times they have not. But the other part of that is that you can test it. So my recommendation, would be not just to rewrite the instructions, but to test them before you sort of implement them and say which ones are most effective at increasing comprehension. I thought I would just give you a couple of examples here. This is from Illinois, where they had used actually had worked with a linguist to look at the instructions, and you can see how different they are in terms of trying to improve comprehension. And I should say that one of the ways in which they've been able to measure comprehension is through the use of vignettes. So the questions that I gave you and I showed you, for factor in favor of a life sentence, the jurors have to, that comes from some work that was done in North Carolina as part of the McCoy decision and Jim Luganbuehl. had done some work there, and he was involved in that first phase of the capital jury project. But as this area of research has sort of evolved, one of the things that researchers have done has been to come up with a variety of vignettes. So it's not just, oh, okay, I get it, the burden of proof is X. What they've done is to come up with a variety of different vignettes and say, okay, here's a situation where a juror has done something. Has the juror operated, according to the law, based on your understanding of the instructions? So it shows that higher level of application of the comprehension, not just, checking it off. In terms of the pattern of findings from the research of the mock jury research, Kentucky is not unique. There's an overestimation of the standard of proof for mitigating circumstances. It's not uncommon for overwhelming majorities of, former jurors, prospective jurors, college students, whatever it is, to come in and think that proof beyond a reasonable doubt is what is required. There is a lot of confusion about the appropriateness of using unenumerated mitigators, that catch-all category that jurisdictions rely on to say, well, we cover anything and everything. There was some wonderful research done in California where really what they found is that those unenumerated mitigators were more likely to be treated as aggravators because of that double-edged sword with a lot of mental health issues than you would have thought in mitigation. Again, the belief that unanimity on mitigation is required, and uncertainty how to weigh aggravators and mitigators, which I understand is not an issue here. And as I've said, they can be improved. Okay, I got it. 5 minutes, so I'll run through as much as I can. I did want to just say that there are some other efforts that are being done to look at instructions. As I said, other jurisdictions have responded to, the issue of jurors' misunderstanding of instructions. Also, the ABA did pass a resolution that urging federal, state, and territorial courts to adopt jury instructions which are in language understandable by jurors untrained in law and legal terms in the penalty phase of trials in which the death penalty may be imposed, and such instructions should be provided to jurors in written form. So there is that resolution that's out there. I also wanted to point out, and I was sort of interested to see that you talked about eyewitness testimony as well, that in New Jersey they have adopted a specific instruction dealing with all the problems with the research, recognizing that the research tells us of all these problems in jurors and that misunderstanding of eyewitness testimony, and therefore they've adopted very specific, explicit instructions that have to be used. So there is some precedent in that area. I was just going to say in California, they've rewritten all their instructions, including capital instructions, in 2006 to have plain language. Somebody's conducted a study to look at that, and you found that the comprehension was not great. It was improved with the plain language instructions, but not as much as one would hope. And my sense of that is because while they did hire a linguist, they didn't test it ahead of time. I bet you had they had this test ahead of time, they wouldn't have adopted that particular instruction. They would have said, oops, we better go back and tweak it a little more. Also, the Center for Jury Studies, which is part of the National Center for State Courts, has convened a study, committees looking at instructions, not unique to capital cases, but just recognizing that jurors as a whole do not understand instructions. So that's going on. They're now working specifically on developing a model instruction dealing with implicit racial bias. And so they're saying that it should be forthcoming in the next few years. I'm going to conclude, because I know I'm got to be probably out of time, with just a couple of last little comments, which the fact is that the pattern of findings that we have is consistent. The path forward, I would say, is also consistent and actually really easily illuminated. We know what needs to be done and what can be done by various groups coming together. That does not benefit one group over the other. What you can do is increase the comprehension and therefore ultimately have greater confidence in the findings of these juries, because one could hope that with this greater comprehension of the instructions, they would actually be following the law and might therefore perhaps result in fewer reversals and the like. The other one little thing that I want to say is just the power of threes. While the instructions are critical, and I showed you, a slide earlier that judges, jurors obviously look to the judges, that does not get the attorneys off the hook for talking to jurors in voir dire and in argument and trying to educate jurors at every particular point that they can. The difficulty is you want to make sure that those are consistent messages. Because judges are held in the highest esteem, it's their instructions that the jurors are going to follow. And so if the attorneys are somewhat inconsistent, not that they're wrong, but they're highlighting different things, it may have slightly less weight. And so to the extent that you can put everything on the same sort of plate, I think that would bode best. Thank you.
Thank you, Professor Sandys. Our next speaker is a man who probably needs no introduction. It's my pleasure to welcome Stephen Bright, who is a native of Boyle County, Kentucky, and a graduate of both University of Kentucky and the University of Kentucky College of Law. Mr. Bright made his name as the director of the Southern Center for Human Rights, where he remains president and senior counsel. The Southern Center for Human Rights, based in Atlanta, is an organization that addresses human rights issues in the criminal justice and prison systems. Over the years, Mr. Bright has represented many individuals facing the death penalty, both at the trial and the appellate level. The recipient of numerous awards, including the American Bar Association's Thurgood Marshall Award, Mr. Bright also was inducted into the University of Kentucky College of Law Hall of Fame in 2000. Mr. Bright is a visiting lecturer in law at Yale Law School, where he has taught for the past 20 years, and an incredibly compelling speaker. We are thrilled that he could be here to join us today to share with us his thoughts on the death penalty here in his home state of Kentucky.
Thank you. Thank you. Thank you very much, and good afternoon, everyone. It's great to be home again. And it doesn't look any different from the day that I had practiced court in this very courtroom. I don't even think the upholstery's been changed since then. But I want to thank Dean Brennan and thank Professor Lawler and the Kentucky Bar and everyone. But I particularly want to thank this law school. Whenever I get a chance, I talk about how great the land-grant universities have been and what a great contribution they made to this country. You know, when I came here to this law school, those of your students now will be interested in this, the tuition was $250 a semester. And going to this law school and getting the education that I got freed me to go out and do whatever I wanted to as a lawyer. And I'm immensely grateful for that. And to be back here almost 40 years later. I also had many great professors here, but I had the best professor in America, Bob Lawson. And in fact, the dean was asking me just a little earlier if I had joined the Bob Lawson Society, and he gave me the form here, and I said, well, you know, when I got this form, it said that to join you needed to pay $25,000. I said, you know, that was my salary for quite a bit of my career as a lawyer. But he pointed out to me that there's some cheap seats down here if you read down just a little further, so I'm certainly going to join, and I hope everyone else will as well. Given my work, you would expect that I'm a little skeptical about the death penalty, but I'd like to talk about four things that I think inform what we're talking about here today. First of all is the emerging consensus against the death penalty. I tell my friends in the South, you may not like marriage equality, but it's the future. And you may love the death penalty, but it's the past. And we are seeing, I think, the march to the inevitable end of capital punishment in the United States. And I'd like to talk about some of the factors that I think have contributed to that. We're talking here about some of the reforms that are essential for fairness in our courts, not just fairness in capital cases, but fairness in all kinds of criminal cases, because there are no small cases in a criminal case. Any deprivation of liberty is a serious matter. But finally, I want to talk about that when we are on the issue of life or death, the limitations of some of those reform, the better in jury instructions, the other kinds of things that the American Bar Association has recommended in its various assessments that it has done, not only in Kentucky, but a number of other states. Let me start by saying on Tuesday we had in Atlanta, where I've practiced law now for the last 31 years, the American Bar Association and the Jimmy Carter Presidential Library had a national symposium on capital punishment to look at where we are 41 years after the Supreme Court's decision in Furman versus Georgia, which struck down the death penalty as it was then practiced throughout the United States. And then to look at what happened during this 4-year period. The fellow named Evan Landry, who teaches at John Jay, wrote a book called Wild Justice, The Death and Resurrection of the Death Penalty. And the death and resurrection of the death penalty took place in Georgia cases and dealt with the Georgia death penalty statute. In 1972, the Supreme Court in Furman said the death penalty was unconstitutional. In 1976, the Supreme Court said that the procedures adopted by Georgia were such that the death penalty could be resumed, and we had the resurrection or the resumption of capital punishment. On Tuesday, we had Dorothy Beasley there, who is a distinguished lawyer and appellate court judge in Georgia for many years, but who argued Furman for the state of Georgia. She was the Attorney General who argued Furman versus Georgia for Georgia in 1972. She was in the Attorney General's office, so she was one of the architects of the statute that was ultimately upheld in 1976. And Judge Beasley said that it is time to abandon the death penalty, that it has not worked since she argued for it in 1972. In March of 1973, Governor Jimmy Carter signed into law the statute that was upheld in 1976. Georgia's death penalty statute. And on Tuesday, President Carter, in his remarks at the symposium, called for an end to capital punishment, saying it was imposed on the poor and the racial minorities and people with diminished mental capacity. He pointed out that the only country in the Western Hemisphere, the only member of NATO that has the death penalty is the United States of America. He pointed out that 97% of all executions which take place in the world take place in 4 countries: China, Saudi Arabia, Iran, and the United States of America. The company we keep tells us something about the compatibility of this punishment with our values. Just a week earlier, John Paul Stevens spoke at the University of Georgia, where I've been teaching this semester. He's the only member of the Supreme Court who was a part of the 1976 decision, Gregg versus Georgia, who is still alive today. And Justice Stevens said that while he had voted to uphold the death penalty in 1976, and he thought it was the right vote that he cast then, of course, that he no longer believed the death penalty was constitutional. He said at the time of Gregg, and this was what Judge Beasley said as well, that at the time of Gregg it was the belief of the justices that there were safeguards that were going to be adequate to protect against some of these problems that the American Bar Association has identified and that others have identified with the death penalty. But that in fact, not only have those protections not been there, but they've been taken down, or many of them no longer are there. Protections that were there before. And then he mentioned what he had said in Bays versus Reese, which is the lethal injection case out of Kentucky, in which near the end of his career on the court, Justice Stevens looked at what Byron White had said in Furman, and Justice White had said that he looked at the frequency of the imposition of the death penalty at that time in 1972, and he said the infrequent extinction of human life with only marginal contributions to any social purpose particularly when the alternative of life imprisonment was available, so that the state was not defeated in its purpose of punishing crime, of retribution, of deterrence if there is any, and protecting the community. Where all those could be served, that the death penalty was excessive and violates the cruel and unusual punishment clause of the Constitution. He followed Justice Stevens, others who were a part of that Furman majority who later expressed their regrets. Harry Blackmun, who later said he would no longer tinker with the machinery of death. As he said, we have tried one thing after another. We haven't ended arbitrariness. We haven't ended race discrimination. We haven't ensured adequate legal counsel for people facing the death penalty. And I am no longer going to experiment with these different processes. Lewis Powell, who cast the deciding vote in McCluskey versus Kemp, which upheld the death penalty despite the racial disparities in its infliction in Georgia, told his biographer that he regretted so much his vote in that case and the fact that the United States still had the death penalty. One of the interesting speakers to me at the Carter Center was Mark Earley, who was a Republican Attorney General of Virginia from 1998 to 2001. Mr. Earley described himself as a cavalier supporter of the death penalty when he took office, but he said after 15 executions, he changed his mind. He said the deck was always stacked against the defendant. Kentucky's had 3 executions in all this time. Virginia had 15 during that 1 4-year term, 110 since 1976. He predicted that the days of the death penalty are numbered in Virginia, and it appears to be the case because in the last 5.5 years, only 2 people have been sentenced to death in Virginia, a state that's executed more than any state except Texas. 110 people. Only 10 people on its death row today, and no death sentences except those 2 in the last 5.5 years, one of those a person who asked to be sentenced to death. This is consistent with what we're seeing in trends all across the country for the last 40 years. In 2000, in the year 2000, George Ryan, the Republican governor of Illinois, who had been a supporter of the death penalty when he was a legislator, declared a moratorium on the death penalty in Illinois. It was sparked by the near execution of a man named Anthony Porter, who was about to be executed, and on the day before his execution, there was a question about whether he was mentally competent to be executed, whether he had an adequate understanding of why he was being put to death. And, of course, if you don't understand why you're being put to death, you're treated until such time as you do understand, and once you understand, then you're put to death. But that was the reason that Porter was not executed. But after that happened, the journalism students at Northwestern not only went out and proved that Anthony Porter didn't commit the crime, couldn't have possibly commit the crime, they actually found and got a confession from the person who did commit the crime. And that was the 13th exoneration in Illinois. And the 3rd exoneration by students in the journalism class at Northwestern. And some people say to me every now and then, well, that shows the system works. But I think the idea that a person like Anthony Porter spends 16 years on death row, and he's exonerated not because of anything the police did or the prosecution, the judiciary, the defense, not anybody in the legal system, but because some students, instead of taking chemistry that semester, took journalism and decided as a class project, let's go out and see if the people on death row are guilty of the crimes they're there for. And as Governor Ryan said, you know, you wouldn't fly an airplane. That was the 13th exoneration. There had been 12 executions. He said you wouldn't fly an airplane that crashes half the time. And he appointed a commission to study the death penalty. They found 4 more innocent people. The commission did. And in 2003, Governor Ryan pardoned those 4 people because they were not guilty of anything. And he commuted the remaining 167 from death to life imprisonment because of the many flaws that had been documented. In 2011, the legislature of Illinois repealed the state's death penalty law once and for all, and it was signed into law by Governor Pat Quinn. 5 other states have abandoned the death penalty during this time. The New York Court of Appeals held the death penalty unconstitutional. After 9 years of having the death penalty, millions and millions of dollars spent to put 7 people on death row, none of them executed. New Jersey repealed in 2007 after a commission that had been appointed, made up of prosecutors, law enforcement, victims' families, business people, legislators, other people, came together, and after, much like the evaluation here, after studying the death penalty in New Jersey, concluded that it takes too long, that it costs too much, that it re-victimizes the victims, that it serves no legitimate law enforcement punishment, that there really was little to show for it after all this time in terms of executions, and that it carried with it the grave risk of the ultimate injustice, the execution of an innocent person. New Mexico in 2009, Connecticut last year, and on May the 2nd of this year, Maryland became the 6th state to repeal or abandon the death penalty. It's likely this next year that New Hampshire will repeal its death penalty. Remarkably, in none of these states, or in any of the states that don't have the death penalty, has there been any effort to reinstate or to introduce the death penalty. This is a trend that's been pretty much in one direction. It's remarkable. In 1994, Mario Cuomo was defeated when he was running for the fourth time, governor of New York, because of the death penalty. Governor Pataki promised that if he got elected, New York would have the death penalty. Cuomo had vetoed it. He would sign it. There was an Oklahoma man who Cuomo wouldn't send back to Oklahoma to be executed. Pataki said he would send him back and have him executed, and he did. And yet, 9 years later, when the death penalty is declared unconstitutional, no effort in the New York legislature to pass a new death penalty. When Governor Cuomo's son ran for governor and was running against a fellow who was carrying a baseball bat around with him to show how hard-nosed he was, the death penalty didn't even come up in the election. Never came up. So quite a difference there. But the death penalty has not just been rejected by people like President Carter and by state legislators, but by jurors. And that's what I think is significant and worth mentioning here and putting in some perspective. There's been a steep decline both in the imposition of the death penalty at trials, which I think is the most interesting, what it tells us about juries and what juries are doing, but also in terms of actually carrying out executions. Both these go again to what Justice White was concerned about, frequency. How frequently are we using this? How critical is this to our law enforcement purpose? In the mid-1990s, we were executing in the mid-1990s, juries were sentencing over 300 people a year to death, 320 being the highest number. The number of executions got up to 98. Never went over 100, but it got up to 98 during the 1990s. By 2001, the number of death penalties being imposed by jurors was down to 150, half of what it had been just 5 years earlier. It had declined to 100 by 2010, 80 in 2011, 78. In the whole United States of America, in this entire country, 78 death sentences imposed by juries last year. Executions have dropped to the mid-40s since 2007. Of course, almost all those executions are in the same place and come from the same jurisdictions. 82% are in the South, the states of the old Confederacy. Texas, Virginia, Oklahoma, and Florida are responsible for 60% of all the executions carried out since 1976. But this is an interesting thing. 2% of all the counties in the entire United States account for the majority of people who have been executed since 1976. 2%. That is, 62 of the 3,143 counties in the United States, 62 account for over half the executions that have taken place. And 20% of the counties in the United States, 20% of those 3,143 counties account for all of the 3,125 people on death row. So while 38 states have the death penalty on the books, although some never use it, and some, like New Hampshire, have one person on death row. The truth of it is that 2%, or at most 20% of the counties are responsible for the people that are under death sentence. And Kentucky is not that much different, except, of course, in how little it has used the death penalty. In Kentucky, there were 17 death sentences between 2000 and 2006, but since that time, in the last 7 years, only 4. So 2 in 2010 and 1 in each of the last 2 years. Kentucky has executed 3 people since 1976, since Gregg versus Georgia. And 2 of those were people who wanted to be executed, people who gave up their appeals and wanted to be executed. In the meantime, 7 people died of natural causes on death row. So it appears to me, as best I can tell, that Kentucky is spending millions and millions of dollars to sentence one, or to carry out one execution every 12 years. Or you could say spending millions and millions of dollars to carry out one voluntary execution every 37 years. And so the question is this really worth the candle? Particularly when you look at the reasons raised by the ABA study that we're here to talk about today. The basic reason, I think, for this change has been the exonerations. The fact that we know now that so many people who were found guilty beyond a reasonable doubt, many of them sentenced to death, were actually not guilty at all. And we were so lucky to find out in some of those cases, Kurt Bloodsworth, the first DNA exoneration from death row, is sentenced to death for the awfulest crime. If ever there's a capital crime, the sexual molestation and murder of a little 4-year-old girl. He stood before the judge before he was sentenced, and he said, "You're sentencing an innocent man." Nobody believed him, and they sent him off to death row. And just serendipitously, when it came back, when my partner Bob Moran came back and looked years later, there was this, because there was no DNA testing at the time of Kurt Bloodsworth's trial. But when DNA came in, they looked at the evidence, and just serendipitously, there's this teeny semen stain left by the perpetrator on the little girl's clothes. Just by serendipity, the evidence hadn't been destroyed. And so it was examined by the FBI. And of course, it turned out not to be Kurt Bloodsworth. And it turned out to be somebody else. And so suddenly we realized that, wait a minute, both Justice O'Connor and Justice Ginsburg, wait a minute, this system that we thought was making correct decisions is making mistakes. As the Canadian Supreme Court said in refusing to extradite, most countries will not extradite anyone facing the death penalty to the United States. The Canadian Supreme Court said the judicial system is and will always remain fallible and reversible. But death will always remain final and irreversible. And for that reason, we're not sending anybody back to the United States of America where they might face this penalty. And it might be something that we ask ourselves, just as Stephen said, we know we've already executed innocent people, and we know we're going to execute innocent people. Carlos de Luna in Texas, Todd Willingham in Texas, Troy Davis in Georgia. And we have the availability of life imprisonment without any possibility of parole. What was so important to Justice White. The state can still enforce its criminal law. It can still arrest people who carry out horrible crimes. It can protect the community from these people. But the enormous cost of the trials and the appeals that we are going through, and it's not fair. It's not fair. That's a due process analysis that the American Bar Association has done. The very first thing, the reason the death penalty was struck down in 1972 was arbitrariness. As Potter Stewart said, being sentenced to death was like being struck by lightning. There was no principled reason why one person got the death sentence and hundreds of other people who committed similar crimes did not get the death penalty. Kentucky has 57 Commonwealth attorneys. They're each elected in their own circuit. There's no consistency, there's no requirement And it's not practical to expect that there's going to be the same practices in Boyle County, where I come from, in Danville, and here in Fayette County, and in Jefferson County, and in Ashland, and all over the state. Each district attorney has his or her own determination. The two most important points made, two most important decisions made every death penalty case. Do we seek the death penalty? And many prosecutors do not ever seek the death penalty. Even in Georgia and Alabama and down south where I practice, we have prosecutors who think the death penalty is law enforcement quackery. And they don't want to spend the time and money on death penalty cases, so they don't seek it. On the other hand, we have other prosecutors that every time there's a chance, they go for the death penalty. That's why Texas has carried out so many executions. Aggressive prosecutors and, as I'll talk about in a minute, inadequate defense lawyers. For a long time, Houston was sending all these people to death. Houston has executed, Harris County, Texas, has executed more people than any jurisdiction except Texas itself. More than Virginia. During the time that Johnny Holmes and Chuck Rosenthal were the district attorneys. And then Chuck Rosenthal had to resign in a scandal, which involved all sorts of things, campaign money, affair with his assistant. But the part I thought was most interesting was the emails with all the racial slurs and all the racial jokes and the racial cartoons. Here's the man who's been making the decision to seek the death penalty. And we find out that he's a crude racist after he served 4 years. And then Pat Lycos, a judge, becomes the next district attorney. And then all of a sudden, we don't have any death penalties coming out of Harris County anymore. We have a different prosecutor. Nothing. Crimes didn't change. Police department didn't change. Nothing changed except the district attorney. Whether or not to seek and whether or not to plea bargain. And, of course, most cases, as you saw in the earlier presentation, are resolved with plea bargains. As the Supreme Court said, we have a system of pleas, not a system of trials. And so most of the cases are going to be resolved with plea bargains. And we see these horrible cases, multiple victim cases, all these cases that are resolved with plea bargains. And then we see other cases that go to trial and end up with the death penalty. The most disturbing thing maybe in the Kentucky report that I saw was the fact that the error rate is 64% in these cases. That in 50 of the 78 cases, they've been reversed either by the state or federal courts. You would hope that the greatest care would be taken in the capital cases. But as I'm going to talk about, that hadn't happened in Kentucky. It hadn't happened in the rest of the country. The most fundamental aspect of having a fair trial and having a fair result and a reliable outcome is counsel, of course. You count on counsel to check out the prosecution's case, mount a defense, and enforce every other right that a person accused of a crime has, a criminal defendant has. And yet, we can't say that it's a principled system to give people the death penalty, not because they committed the worst crime, but because they had the misfortune to be assigned the worst lawyer. That's no system, is it? And yet there are no greater and more blatant violations of the right to counsel than two that occurred here in Kentucky. When I take up counsel in my class, I start by saying, how do you enforce the right to counsel? The right to counsel is your most fundamental right. But what do you do if you're Gregory Wilson? What do you do if you're facing the death penalty in Covington, Kentucky, and the judge assigns William Hagdorn to be your lawyer? And you find out that Mr. Hagdorn has been suspended from practice a number of times, that he practices out of his home with a big Budweiser beer sign on the wall. I always ask people, if you were going to get a will or a divorce or just some minor thing, if you went to the law office and there was a Budweiser beer sign on the wall, you think you'd stay, or you think maybe you'd ease on down the street to maybe find somebody with a little mahogany and some law books? They may not use those law books, but they've got that mahogany in those law books to tell you something, right? That they're serious about practicing criminal law. Mr. Hagdorn's home had been raided by the police just shortly before. They'd taken 8 bags of stolen property out from under his living room floor. But what really got Gregory Wilson was that when he called the number Mr. Hagdorn gave him, they answered Kelly's Keg. He Any of you from Covington? I've been to Kelly's Keg myself. It's a bar right across the street from the Kenton County Courthouse. And it actually worked fairly well. If you call that number, the bartender would answer, and usually he could summon Mr. Hagdorn to the phone, but very often Mr. Hagdorn wouldn't remember the conversation the next day. And so Gregory Wilson goes before Judge Lape, and he says to Judge Lape, you know, I'm facing the death penalty. I don't have a friend. I'm from Detroit. I don't have a friend anywhere near. I need a lawyer. I need a real lawyer. And Judge Lape said, well, Mr. Wilson, you're welcome to have any lawyer you want represent you in your case, but this is the lawyer the court is giving. And every time they come to court, Mr. Wilson objects to his lawyer, and you can imagine this is not doing much for the attorney-client relationship. The case goes to trial, and the trial is a mockery of justice. Mr. Hagdorn's not even there for parts of the trial. And one memorable part of the transcript, the judge says, do you want to cross-examine? And Mr. Hagdorn said, well, I'd like to cross-examine, but I didn't see the direct. If you haven't taken evidence yet, let me just say, before you cross-examine a witness, it's always good to see the direct. But the judge in this case said, well, I'll tell you what I'll do. I'll summarize the direct, and then you can cross-examine. And that's what they did. I kid thee not. Gregory Leonard, represented by one of the 10 lawyers, disbarred or resigned from the bar because he was facing charges of perjury in Gregory Leonard's case. This lawyer knew so little about Gregory Leonard, he didn't know his name. And Gregory Leonard was tried under the name James Slaughter. He didn't know that he was brain damaged. He didn't know a lot of things about him. And yet, in both of these cases, they went all the way through the court system. In any system that makes even a pretense of being about fairness, surely these cases are scandalous, embarrassments, front page news. We should be asking, why did they happen? How did we let this happen? And how do we make sure it never happens again? And yet, both of those cases upheld by the Kentucky courts, by the federal courts, by the Sixth Circuit. Boyce Martin just wrote another dissent case recently before he left the court. In a system of justice, these cases would be reversed on the proverbial phone call and sent back for new trials with competent counsel, but they were not. Because they're just a little bit worse than so many other cases. Because we've accepted a standard of legal representation that's so low that we'll dip even a little bit lower in these kinds of cases. Another person sentenced to death in Kentucky, represented by a lawyer disbarred for mail fraud, who had accepted money that had been obtained in an armed robbery and a murder as his fee. You know, Clarence Darrow once said that he was a guy that committed robbery, offered to say he didn't have any money to pay his fee, but he could come back with some pretty soon. And Darrow said he didn't want to be paid with money that had been stolen that recently. But it wasn't a problem for this lawyer. It wasn't a problem for this lawyer. The law students here ask, what kind of legal system are we accepting? What kind of legal system? How does the Kentucky bar tolerate this? I don't understand it. How are these people allowed to practice law? That's the same thing in Texas. About lawyers who miss the statute of limitations, lawyers who are incompetent. We're talking about life or death here. We're not talking about some grading a will and all the lawyers getting rich. Well, the bar doesn't usually do anything about that either, but at any rate. People who are well represented don't get the death penalty. That's why there are no wealthy people on death row. Virginia, I was talking about how there's no death sentences, only 2 in the last 5.5 years. For years, all these people represented by court-appointed lawyers in Virginia, not compensated very well, not provided investigators mitigation. And then they created these 4 regional capital defenders, and now people are represented by lawyers who actually know what they're doing. But lawyers who actually know how to represent someone in capital cases. Lawyers who have on staff mitigation specialists to investigate mitigation and investigators and all that. And these 4 offices, which are not without their troubles, nonetheless have all but shut down the death penalty in Virginia. The same thing happened in Philadelphia. Or even in Texas, there's a public defender office called the regional public defender for capital cases that operates out of Lubbock and has taken on representation of people in death penalty cases in more and more and more counties in Texas, and its clients are not sentenced to death because they have lawyers that know what they're doing and lawyers who are capable. The ABA assessment says the Kentucky public defenders are underfunded and overworked, and that's true here and that's true all over this country. But the question is, how do we get Kentucky? How do we get any government that seeks to convict and execute people to pay someone to frustrate those very goals? And that seems to be a problem that's haunted us ever since Gideon versus Wainwright. As Robert F. Kennedy said, the poor person accused of a crime has no lobby. And unless the legal profession, unless the judiciary takes the leadership and says we have to have well-funded public defenders, we have to have well-funded capital defender offices if we're going to have the capital, if we're going to have the death penalty, it's not going to happen. The capital trial is an enormous undertaking. And it takes an enormous amount of resources if we're going to do it. If for that one execution every 37 years we're going to do it, then we've got to pay the price to do it as close to as right as we can. We got to talk about race, because capital punishment is bound up in the terrible history of race in the United States. Capital punishment was essential for the institution of slavery. And if you look at historically about states like Michigan, which abolished the death penalty in 1846, and some other northern states which did even before the Civil War, and then after that, the northern states were restricting the death penalty almost exclusively to murder cases. But that couldn't be done in the South. Couldn't be done in a slaveholding state like Kentucky. Because after all, if you have a captive population, if you have people who are already virtually prisoners, the only punishment you have left is the death penalty. And of course, the death penalty was given out pretty frequently to people of color. And after the Civil War, when we went to convict leasing, when slavery was really perpetuated all the way to World War II in Alabama, people were being leased to the railroads and the coal mines and the turpentine camps and all that. These are people just arrested on little minor charges, loitering, whatever, and then leased away. You had to have the death penalty. George Wright wrote a great book on legal lynchings in Kentucky, the death penalty and legal lynchings. He talks about a case tried in Kentucky that lasted only 1 hour. And right after this hour-long trial, the person was taken out behind the courthouse and hung. And the Courier-Journal wrote an editorial, and they said, well, it was pretty hasty. But at least we didn't lynch him. This was seen as a great move forward. But the perfunctory capital trial, where the mob was told, just let the law take its course. Everybody knew what was going to happen. These cases weren't going to be fairly tried. These people weren't going to have real lawyers. It was going to be all male, all white juries. And of course, Jim Crow justice and now mass incarceration, which falls so heavily on people of color. William Brennan is a remarkable man. I thought that one of the most remarkable things he did on the Supreme Court was his ability, from the majesty of the high, lofty place of the Supreme Court, to imagine a conversation between a lawyer and his client in some jail in this country. He said at some point, Warren McCluskey must have asked his lawyer what was the chance he'd be sentenced to death. A candid answer to that question would be very disturbing, because the lawyer would have to explain to McCluskey that neither the crime that he was accused of nor the record that he had would be as important in determining whether he was sentenced to death than the race of his victim and McCluskey's race. And he talked about the statistics, and he said you could tell the story a number of different ways. But the inescapable lesson for Warren McCluskey was that race would matter more than almost any other factor in whether he was sentenced to death. Kentucky is to be commended for passing a Racial Justice Act. North Carolina did it, actually litigated some cases and found that race had an influence on the death penalty in 4 different cases in North Carolina. So the North Carolina legislature immediately repealed the Racial Justice Act, which I suppose deals with racial discrimination in North Carolina in the way in which that current legislature is inclined to do. The Supreme Court said in Turner versus Murray and in McCluskey that you have to minimize the risk of race coming into play. But are we willing to tolerate a certain amount of race coming into play in a decision as big as life and death? I mean, we tolerate so many insect parts in our cereal, so much arsenic in our water, but do we tolerate a certain amount of racial bias in the people we condemn to die? Should we eliminate any chance that race plays a role? If we do, there's only one way to do it, and that's to eliminate the death penalty. It's the only way it can be done. How much uncertainty are we willing to tolerate with regard to executing people of low intelligence? We used to be called mentally retarded, intellectually disabled, people who are profoundly mentally ill. Can we ask our juries to measure the degree of culpability of an intellectually limited person? Are they so intellectually limited that they're exempt from the death penalty? Or are they not quite intellectually limited enough so that we can execute them? For a profoundly mentally ill person, is this person so profoundly mentally ill that we don't find their degree of culpability to be the same as the culpability that you and I would have? And therefore they're spared the death penalty? Or is their mental health, which we don't understand at all, we're learning more about every day, but is their mental condition such that it's not quite to the extent, and therefore they should be executed? Or is their mental condition such that they are a danger to other people, a danger to society, a future danger, and therefore they must be executed? Well, you can ask different people to make those decisions, but there's no way that they're going to make it consistently. You know, I don't think a person can make that decision. How intellectually disabled a person is, how mentally ill a person is. If only we can understand, we're learning more every day about how the brain works, but we have so far to go, and it gets so trounced in our adversary system. Somebody was saying the other day, and I've had the same thing with clients who, it was always the prosecution's theory, these people are malingering. There's nothing wrong with them. Then they're condemned to death, and they go to death row. James Andrews, the fellow I've represented for the last 20 years, he got to death row. And the people there were concerned with his behavior on death row. This was a man who's totally out of touch with reality. And so you look at 20 years' worth of prison records, and they don't hesitate to say that he's schizophrenic. They don't hesitate to use psychotropic drugs to treat him. Of course, that wasn't the state's position at trial. But now that he's condemned to die, now we face the fact that he's schizophrenic, that he's out of touch reality, that he even has to be forcibly medicated against his will because he cannot function with other inmates. How do you factor in the unspeakable abuse, sexual, psychological, physical, that so many people facing the death penalty? It doesn't excuse the crimes. It doesn't make it okay. It's not all right. But it certainly is something that you use in calibrating culpability. But how do you do it? How do you do it consistently? It can be done, and no two people will do it the same way. Of course, we've got to pursue these reforms. We've got to pursue competent counsel, prosecutorial accountability, full discovery, better jury instructions, all of these things. Not just, as I said at the outset, for death penalty cases, but for courts to be more fair in all kinds of cases. These are things to ponder. But there's also a larger question that I leave you with here finally. And that's, what kind of society do we want to be? What kind of people do we want to be? I grew up in Kentucky, and I always thought Kentucky was special. And I thought Kentucky was not like a lot of other southern states. I remember when I was in, elementary school or maybe high school, and the big issue of the day was race and the question of integration. And Burt Combs, the governor of Kentucky, signed an executive order that public accommodations in Kentucky would be integrated. Just like that. When George Wallace was standing in the schoolhouse door. When everybody else in the South was in massive resistance And of course, there was plenty of that going on here too. Winston Churchill is one of many people over the centuries that said we judge a society by how it treats its criminals and its prisoners. You can ask the question, does the society torture? You can't mince that, like the Bush administration tried to do and try to redefine torture. I mean, you either torture or you don't torture. And if you torture, it tells you something about that society. Does it kill? Does the society kill? That tells you something. That's a bright line about that society. The Constitutional Court of South Africa, in deciding on the constitutionality of the death penalty in South Africa, said we are a nation on a journey from hatred to understanding and from vengeance to reconciliation. And in the society we are building here in South Africa, there's no place for the death penalty. In the kind of understanding society, reconciliation society, there's no place. I think it's increasingly clear that the death penalty's demise is inevitable, and the question is, are we going to wait and be last, or are we going to be ahead of the curve? I think the better angels of our nature, as President Lincoln said, may finally be ready to recognize what Supreme Court Justice Arthur Goldberg said long ago when he was on the court, that the deliberate institutionalized taking of human life by the state is the greatest conceivable degradation of the human dignity that is possible. But there's another part of it. It's not just degrading to the person who's put down and tied down. It's degrading to the society that carries it out. It coarsens the society. It tells the children of the society how we solve our problems and how we use violence and our reverence for life. I believe ultimately we will conclude that, like ear cropping and branding and lashing and slavery and segregation, that the death penalty is a relic of another era. We are capable of a more constructive approach to the problem of crime in our society. And when we settle on that, I think we'll join the rest of the civilized world in making permanent, absolute, and unequivocal the injunction, thou shalt not kill. Thank you.
We now have a slight break. There's a snacks outside, I believe, so we'll see you guys back here, I believe, in about 20 minutes. 15 minutes.
you all can grab second, right? I mean, like. Do we need to move chairs from the jury box? It's kind of uneven. I don't know. Yeah. We need 11 chairs.
Sort of.
I'm going to move this back so they can see each other. All right, let's look. Something's in the way. Oh, that cord maybe.
Oh, and also I see the. See, this is the little button.
Ready, lift up. There we go. There it went. All right, I think that's good, don't you? No, not all the way. You might want to scoot the table out a bit because they won't have any elbow room. Yeah. Okay, so we only need 10 chairs.
Oh, good. Robin Webb's not coming, is that what it's
Right.
The bulb looks like it's having fun, doesn't it? Test, test. Test, test. So what we're going to have to do, since there's so many of them, is have them pass these handhelds.
Right.
Do you want your own mic? We don't have another handheld.
I'll stand up there for the beginning, and maybe I'm not gonna. I had decided I was going to sit down, so while people are talking. I don't know if it's easiest for me to go back and forth.
I mean, we can put one of the table mics out
In front of
you.
Oh, if that works, that's fine.
Yeah,
I mean,
we can have 3 wireless mics running at a time, so we've got one more channel.
yeah, if that works, that'd be great.
Guess I'll do 4 over there.
It's got to stay plugged in.
Oh, okay, you're good.
Do you know where you're going to be?
Apparently on the end. Yeah.
This person probably won't be the handheld. They'll get picked up by yours.
Mitch and Allison. Okay, that's Allison, so it'll be fine.
Okay. Like I said, they will need to close out. And I gave Courtney a table mic so that she doesn't need one. You're welcome. Looks like it went back.
Indeed, I do.
Maybe it's where we moved it. It's like, no thank you.
It's like, no, don't do that. I'll kind of hang out outside till I'm sure everything's going well.
You're right.
And I told Courtney.
They can get into from the sides. That person can get into from the side.
Are we leaving this?
Yes. You can mute it right now if you want to, though.
made it. I made it. Hey, buddy. You came over, okay? It's okay. Good, Tony, good. Big group.
Yeah.
Are you emceeing it? Are you emceeing it? Yeah, I've seen her today. Seems like she does a pretty good job. Yeah, thank you. She's told me she's going to make me stand.
Another person said.
Yeah.
I think Ernie was the one telling me that.
Do what the hell happened?
Well, is he still in the room? Can you point him out? Is he still standing?
Yeah. It didn't take any long.
That's all.
What's Carolyn doing? I'd like to touch base with her for a while. Yeah. Good. Absolutely. Well, sure. Just put my name on it. Put my name on it, too. That's what we've been doing, just putting different names on it. Just put my name on there. I'll join in. Yeah. Oh, yeah. Okay. Yeah, just email it to me.
I will keep that very close in mind.
How you doing? Good to see you. Good to see you. I know who you are. Good to see you. You're not changed.
No, it doesn't. You know what? I wish there were a side door because there are too many people out there distracted.
Jim Keller. Side access. That's okay. That's okay. I may not be now. I was going to show you something here. I'm going to say it. Allison, you know Jill Holbrook.
Yeah.
I went by her offices yesterday when we went to lunch, her and Kim Lemons and I. Wait a minute, now what's it there? How about that? Jill said it had that bathroom there, and so she just went ahead and you know, they got other bathrooms, a couple of others there, and she said instead of just demolishing that bathroom, putting something else in it, she said it wasn't big enough for anything else. It's not. And the guy said, "Well, I'll fix that up for you." And so. 11.
I had no thoughts about it.
Tom, do you like it?
You know, I must be
Are you
sick.
enjoying it?
I must be sick.
Yeah, oh yeah. That's okay. Yeah.
I think I must be on doing something illegal.
Yeah. Well, you don't need to retire. That's
what I don't want to do.
That's a bad thing people are doing. They jump
Yeah,
up
I
and
guess
retire.
better after us.
Hell, I don't have any thoughts about retiring. And one of my friends the other day, actually this week, told me, he says, you know, Jim, I was getting ready to retire. I talked to you a couple of months ago. He says, I'm not going to retire. He's younger than me. No, I take back. He's older than me. About a couple of years. He said,
Let me give you a heads up.
there's no reason for you to retire, you know?
Before 4:30. Probably 10 or 4 even.
Somebody tell me today that they
Yes. So,
Tom Carter
you should.
was thinking about retiring, and
This is the last minute thing that both
several
of
years
us
back,
Yeah, he's my rep. I'm his senator.
State's closed down the state office. And his wife said, you know, your birthday's tomorrow.
It's good to meet you.
Eugene. He said, okay, that's fine. So they went out by Eugene, and he said, you know,
Like the circuit clerk had it.
And she said, well, you know, our daughter is something's coming up. I got to get her or something. So it took my wife 3 hours to find the dress she wanted. So I said, in the meantime, I wandered through them. And I saw all these guys.
We are well represented.
Sleeping, watching TV. And he said, that's retirement. I don't want it.
Allison, you know that case that Steve was talking about up there in North Kentucky on the former attorney. You know how you find that case on Westall real quickly. Because there's a good thing in there about what you need to ask, you know, where somebody wants to represent themselves and everything. But you know how you find it.
How are you?
You type in ask. Because when you raise you know, I said, I don't believe I done that. You know? Yeah. Malibu, California. Where's Malibu?
Malibu?
Whereabouts is it in California? Is it north or south?
It'll be south of San Francisco.
Oh, well, that's where my young. Oh, I bet she got that job. She's in Santa Cruz right now. Or she lives
a cookie in his hand.
Yeah, so Malibu's close to there, not too far away. Okay.
Might be good.
Okay, we're going to go ahead and get the second part of our afternoon started. Okay. I'm going to give just a couple of one-line introductions about our panelists because I would like to spend most of the time allowing you to hear from them and to get their responses related to both the report itself and the recommendations of the committee as well as to the presentations this morning. So starting at my right, your left, we're starting with Professor Allison Connolly, who is a professor of law here at the University of Kentucky and a former public defender of many years and the first female public advocate for the state. Thomas Wine is the Commonwealth's attorney for Jefferson County. Justice James Keller is a retired Associate Justice of the Kentucky Supreme Court. United States Attorney Carrie Harvey serves the Eastern District of Kentucky. Representative John Tilley is parking his car and will be here momentarily. He is a member of the Kentucky House and chair of the Judiciary Committee from Christian County. Senator Whitney Westerfield also represents Christian County, as well as Todd and Logan counties, and is also a practicing attorney. Justice Martin Johnstone is also a retired Kentucky Supreme Court Justice. Secretary for Kentucky Justice and Public Safety, Michael Brown, is also a former district court judge in Jefferson County. And then Larry Simon is a criminal defense lawyer in Louisville and former prosecutor for Jefferson County Circuit Court. Unfortunately, Senator Robin Webb was unable to join us, so this will be our panel for today. I thought I might wait and see if Representative Tilley came in, but I'll go ahead and start. What I wanted to start by doing is giving the panelists each an opportunity to give us their initial reflections and thoughts about what we've heard this morning and about the report before moving on to specific questions and eventually, obviously, taking questions from you all. So we're going to start with Professor Connolly, and then each of the other individuals will go down the row.
I have to stand up. I can't sit down. Those of you that have me in class know that. I was trying to think of how to think about what we did for this 2-year period. And of course, we're coming on to probably the most studied murder in the history of our country, the assassination of John Kennedy. And not only did we lose a president in 1963, 50 years ago this month, but his assassin was shot down in an act of vigilante justice. And since that shooting, that taking the law into their own hands, the American people have had questions about what happened, who did it, why did it happen. And we, to this day, have conspiracy theories or this magic bullet, single shooter, we don't know. I guess that's why, my motto has always been question authority. Because Walter Cronkite said at the time, after the Warren report that looked at the assassination, this is the point that America lost trust in its government. Felt there was a cover-up, that we didn't know everything. I treat this report in the same manner. We approached it in the manner of there are questions out there that should be answered, that need to be answered. We need to look and see, is our system fair? Is it accurate? That was it. And so we employed a wide panel of differing viewpoints to see if it was truly fair. We asked a lot of questions. Because if you don't ask questions, you don't get any answers. And then you don't trust anything. So really, I have from today more questions than answers when it comes to the prevention of wrongful convictions. Why don't we have legislation that requires any lab that does forensics to be accredited? To have our medical examiners be accredited? Why not? Couldn't cost that much money. Certainly doesn't cost as much to imprison someone or seek the death penalty. Why don't we have some kind of training on the proper preservation of biological evidence? Why don't we have written policies, kind of the best practices governing the collection of biological evidence? If you ask why, you say why not? Because the answer is so simple, it couldn't cost that much money. Why don't we have a jury instruction that basically tells us whenever identity is the central issue in the case, you just look at factors to be considered engaging eyewitness identification? Why don't we have that? We know from exonerations that 50% of those exonerations are due to misidentifications. And it's so easy. All it takes is a criminal rule to change. Why don't we have statewide guidelines on how you conduct a lineup or a photo spread? Or why don't we videotape our confessions? Don't you think those pesky defense attorneys would hate a videotaped confession where the Mirandas were all in place? Everything was by the book? It's when it's not that way that we distrust our government. And what about this inconsistent application of the death penalty that Steve Bright talked about? I mean, we've got prosecutors here. One, the Eastern District of Kentucky's prosecutor, Kerry Harvey. He has guidelines that he follows whenever he exercises or seeks a death sentence. He has to go up the chain. He has to ask the U.S. Attorney General, we think this is a valid case, to seek the death penalty. And yet in Kentucky we have absolutely no written guidelines at all for the exercise of prosecutorial discretion. Why not? That's so easy. That's so commonsensical. Just doesn't make sense to me. And open file discovery? The prosecution of a death penalty case, of any case, is not a game where you hide stuff. So why is it you have to fight for discovery from a prosecutor, especially at the post-conviction stage? What's the big secret? Why are we doing that? And lastly, I guess, Marla Sandys really hit home with me. This juror confusion. How hard would it be to have some jury instructions that really explained mitigation? You know, what is mitigating evidence? I think we could do that as a bar. 46% of people failed to understand they could consider mitigating evidence at sentencing. One of those instructions you saw required the education of not even a law student, a lawyer who'd been practicing for a year. And yet we have 20%, only 20% of our population has a BA. And we want our jurors that we trust to impose a sentence and understand what we're saying. So I ask you, why not? We brought this report out in 2011, and it hasn't really moved an inch. We made recommendations, good common sense recommendations, many of which would cost no dollars, no money. And we haven't seen any response. You know, maybe the answer is there's no answer to that question. And maybe the answer is, as Steve pointed out, and as Justice Blackmun said so well, no longer should we tinker with the machinery of death.
Well, thank you very much. My name is Tom Wine, and I'm the relatively new Commonwealth Attorney in Jefferson County. Previous to being sworn in January of this year, I had served 5 years on the Kentucky Court of Appeals and 15 years prior to that as a trial judge, 10 years before that as a prosecutor and assistant Commonwealth attorney, and 2 years of private practice mixed in that mess somewhere. You know, I operate on some very simple premises. If they're arrested, they're probably guilty. If they got indicted, you know they're guilty, and we don't want to send anybody to the electric chair on good evidence. Now that I have your attention, and perhaps shocked you a little, let me say that, and I also want to ask this question. We just had a prosecutor's symposium here in Lexington and dealing with capital litigation, and there was a challenge to the prosecutors there if they would come over and attend this symposium. Have any of them shown up? Okay. All right, so you and I are going to be the piñatas today, if that's all right. So, yeah. In 2012, I had a chance to look at the study that they referred to, and it's one that is very thorough. It's one that leaves me with some questions, and some of those, and again, it's not to challenge the veracity of those men and women who served on it. I think it is interesting that the number of prosecutors is limited, if at all, on the panel, and I'm not sure why that happened. It's also kind of interesting that you see that here in Kentucky, 50 out of 78 cases that resulted in convictions were reversed for one reason or another, and yet we don't talk about the number of cases that were subsequently retried and the death penalty was once again imposed. In the information that you have, they've listed a number of cases that have been reversed over the years, even beyond this study over the last 10 years. And in the ones that I was able to find that they had listed that were retried, one ended in a not guilty. And all the others, either the jury imposed some penalty, including death, or there was a plea. So the vast majority of those cases that were reversed, there wasn't a question of guilt of the individual. Most of the time we got into problems with the sentencing and whether or not the instructions were correct and whether or not the death penalty instructions particularly were correct.
It's interesting, the poll that was given. I looked at that, and the one thing that's missing, and perhaps it's somewhere in the material on the ABA website, but what was the question that was asked of the individuals, and they came back with the answers of how many people were in favor of a moratorium or in favor of doing away with the death penalty? Because as we know, sometimes it's what's being asked that gives us the answer that we may want, and I think that's something that we may want to consider as well. Another consideration is that in many of the reversals, 18 of them by my count, that involved cases that were tried before 1990 were because there were changes in the law. And, you know, how can we hold a prosecutor or a defense counsel to a standard that didn't exist at the time? Now, those were reversed, and they were subsequently retried in almost every one of those cases. It's interesting when we talk about the questions about jurors, as I understand the information, 40% of the jurors misunderstood their obligation in imposing the death penalty, and yet, how often has the death penalty been imposed in Kentucky? And it is true that we are concerned about the level of intelligence or education of our jurors. Several years ago, I was called as a juror and made it through the voir dire and subsequently was struck. And my good friend Larry Simon was on the panel, was one of the lawyers, as well as one of the prosecutors that I know well. And he said, "Would you like to know who struck you?" And I said, "Well, I'd be kind of interested because both of you seem to be pretty satisfied by the way the questions went." He said, "The judge struck you for cause because he's afraid you'd know too much about the case and know too much about the process." So 20 years of education worked to my detriment in this particular situation. I appreciate very much Mr. Bright's comments. And it's interesting because we started out with this program, or rather this evaluation, is not really whether or not we should or shouldn't have the death penalty. It's whether or not it's going to be applied fairly. And we slowly morphed into we really shouldn't have the death penalty at all. And among those reasons was the cost that we incur for death penalty. And I think you really have to look at what would be the cost of trying a case of life without parole as the highest punishment possible, and then the difference between the death penalty. And respectfully, all the money and time and energy that is spent, and I think appropriately so, in making sure that the death penalty is appropriately applied. If the death penalty were eliminated, do we really believe that all that energy and all those persons are suddenly going to fade away and say, okay, we're satisfied now that life without parole is not cruel and unusual punishment? I think we change our focus. I think the comment, though, is very important. What we really need to be concerned about is that people get a fair trial, and that no matter what, whether it's a traffic ticket or death penalty, that people have to have confidence when they go into our courts that our judges are competent, that our prosecutors are competent, our defense counsel are competent, and ethical for all three of those, and that they are not going to be motivated by politics. My predecessor, with all due respect, made a decision that he would never not indict a case where the aggravators were present. So every case where there was a robbery or murder involved, robbery or rape or extensive prior criminal history of assaultive behavior that might exist along with that murder, they were indicted as capital murder. We have changed that policy, and we go through and we review. I review with the prosecutors. I ask the victim advocates to talk with the family to see where they stand on the issue. And one of the considerations that was specifically precluded from consideration by the Commonwealth Attorney himself the last time was whether or not a jury would impose the death penalty. And I think that's an important consideration. And I think that's based upon the community that you live in, which is unfortunate because I understand the earlier discussion that where you're born, where you live, may decide whether or not you get the death penalty if you're in one of those 62 counties here in the country. But I think that's an important consideration. And not only do I apply that to the cases that have arisen since I've taken over, but we went back and applied that to previous cases as well. And as a result, we've pulled the death penalty as a possible punishment in several cases. We may still pursue capital punishment. And in one recent case, we did that. We went forward with life without parole as the highest punishment. The jury came back with life without parole for 25, which is what we offered. So we evaluated correctly. The jury was never going to give the death penalty. We came up with what we thought was an appropriate punishment. The defendant said, I'm not going to take that. It took a jury to do it, and so I think the system worked. So I'm not afraid to exercise my discretion, and I think that other prosecutors should do that as well. The failure to exercise discretion, quite frankly, is no exercise at all, and I think that really defeats the whole purpose. So I really appreciate the work again that the men and women did on this program. I think that there are some things that we do agree with as prosecutors. We want a conviction that's going to stand the test of review. It makes no sense, and if you've ever had a chance to read the book Convicting the Innocent, it makes no sense to prosecute and convict somebody that didn't commit the crime knowing that the true perpetrator is still out there. And so forced confessions, those type of things, really make no sense to me as a prosecutor, and it certainly makes no sense to me as a person in the community that's concerned about the safety of our people in this community. Thank you.
I'm not going to give a lot of comments here. I'm going to be fairly short because most everything that can be said will be said already, or it's going to be said by other people. But I was on this commission, and Tom asked the question, why wasn't there prosecutors on there? There was a prosecutor on there. I'll leave it at that. He left voluntarily from the commission. But and that wasn't our fault. So we thought there should be a prosecutor on there. This cross-section, when I was asked to be on this commission, no one asked me, how do you feel about the death penalty? That question wasn't asked. I'm not opposed to the death penalty. I tried numerous capital cases, had a conviction in one of them where the death penalty was imposed. It was set aside on appeal, but so I've never said that I was opposed to the death penalty. I am opposed to executing innocent people, and we've got problems with our death penalty procedures in Kentucky, and we need to correct those problems. It takes money to correct those problems. This report, 500-some pages, set out the problems we have with the death penalty, and we need to have those examined, and we don't need to be executing people until we make sure that they should be executed. And so that's my simple position. Now, you can look at the report, but if you want two simple reasons why it's not working. One is look at the reversal rate. That tells you pretty quick that something's the matter if we got this high percentage of reversal rate in these death penalty cases. And in 36, 37 years, one person has been executed involuntarily. One person. So, we got the death penalty in Kentucky. What's it accomplishing? It's no deterrent. Somebody sits on death row for 37 years and dies of natural causes. One of the things that Steve Bryant said that I've told my children a different thing about the death penalty. I said the death penalty will probably be abolished in your lifetime in the United States. Certainly in my grandchildren's lifetime. And so if we're going to have it, if we're going to have it for the future, for any period of time, we need to correct the problems it has at this time.
I think as Mr. Wine said, there are two questions here. One, of course, is the debate about whether we should have the death penalty in our Commonwealth or in this country. Frankly, I can't add a whole lot to that because I have no more say in that than any of you. I get to vote for a state representative and a state senator and a congressman and 2 federal senators who express our will, and they decide whether or not the death penalty will be available as a punishment. The Supreme Court, as I understand it, has said that in theory, the death penalty is constitutional. So that's not an argument that we're going to settle here today. And again, whether or not the death penalty is written into statute is ultimately a reflection of the public will. It's up to you all. It's up to everyone who lives in the community. I think our elected representatives, one way or another, generally get to where the public is. And I think where we are in Kentucky is probably where most of the public is. When that changes, I expect the law will change. From the viewpoint of the federal system, the death penalty imposed in federal courts really have its supplemental jurisdiction. The huge majority of death penalty cases arise through the state court system. I do think there may be something to be learned for how the death penalty is administered in the federal system. The death cases that we have, and thank the Lord there aren't that many of them, because I'll tell you, if there's any idea that prosecutors are out there looking to be involved in death penalty cases, I would disabuse you of that notion. The few death penalty cases I've been involved in, I hate everything about them. But it's my job to try to fairly administer the law and represent the United States in these cases, because the people of the United States have made a decision that in certain cases the death penalty is a punishment that will be available. And we in the United States Attorney's Office represent the people of the United States. We do that the best we can. And there's no question that the report of this commission is superb work. I think one thing that there is universal agreement about is that if we're going to have a death penalty, it needs to be imposed fairly, equally, and with as much justice as we can bring to bear on these cases. When we see federal death penalty cases, they usually arise in a couple of different contexts. One is that in the Eastern District of Kentucky, you may not know this, but we have more federal prison facilities in our judicial district than any district in the country. It's a good economic development tool, but if you're the U.S. Attorney, that's a mixed blessing, because those fellows create a lot of work of a lot of different kinds. And you have very dangerous people in our federal prisons. You have people who have the capacity to fashion a deadly weapon from a styrofoam cup. So bad things happen in some of these federal prisons, and sometimes we have inmates who are simply incorrigible, and they assault staff and they assault inmates, and you have, again, when you see cases where the death penalty is not justly applied, it's horrible, it's repulsive. But there's also a lot of repulsive criminal activity. When you see inmates in our federal system who entered the federal system because they said to their partner in crime that I'm going to kill the next person I see, and the next person they see is an elderly gentleman walking into a church and they shoot him down, that's a pretty repugnant thing too. And then when you see the same gentleman who enters the federal prison system and assaults one cellmate after another, one staff member after another, who on a number of occasions kills those that he comes into contact with, that's an issue. And in some cases, the judgment is that in order to protect the Bureau of Prison Staff and in order to protect other inmates in federal penitentiaries, that's the only method left. The other area where we would see death penalty cases would be when a federal agent is killed, or when informants who are working with federal agents are killed. And we've seen those cases. We've seen cases where people are working with our agents to break up massive drug rings, ties to Latin American cartels, and they're discovered. And we have cases in our district where those people were tortured and killed and burned beyond recognition. In those sort of cases, the federal death penalty is an available option. The mechanism that we use to reach charging decisions in the federal system, I think provides a useful area of study to solve at least some of the problems in the state system. If there is review at every stage of the process, ultimately, in order to seek the federal death penalty, the Attorney General of the United States has to personally sign off on that case. The process is something like this. If we see a death-eligible case in our jurisdiction, we make a decision locally as to whether or not we want to seek the death penalty. If we do that, then that ultimately is my decision. It goes to a group in Main Justice in Washington of career prosecutors, the Capital Crimes Unit in Washington. They review the material. Ultimately, they make a recommendation along with our recommendation to the Deputy Attorney General of the United States and the Attorney General. Before we get to that point, there is a process whereby the defense attorneys have an opportunity to come meet with us, meet with me, and present their reasons as to why the death penalty is not appropriate in that case. And I can tell you that's not a rubber stamp procedure by any means, because at least in our district, I'm not looking for reasons to seek the death penalty. I'm looking for reasons not to. And I think that's true of most of my colleagues. I think the benefits of that sort of review process is that it does promote a certain degree of uniformity in the application of the death penalty, because you have presidential appointees at every level of the process who are members of the same administration all over the country who are reviewing these cases. Ultimately, the central authorities in Washington have to sign off on these cases. So I think you do gain a certain benefit from that, in that you don't have prosecutors in Kentucky applying completely different standards, unfettered discretion that would lead to a completely different result than a prosecutor in New York. I think there's some benefit to that when we talk about the fair administration of the process. On the other hand, in Kentucky, and again, I think so many of these issues really get back to the will of the people. We elect prosecutors in Kentucky, and we invest them with great discretion to work the will of the community. And so this is not, I don't know how I would come down on that debate, but I simply point out that there are those who I'm sure would argue the other side, and they would argue that prosecutors who are elected should have the discretion to work the will of their community. But I would at least commend the federal procedure to the review of our legislators on the state level, because I think that procedure does solve at least some of the problems in the charging decisions. We also, I think, have a very sound system in the federal courts to make sure that people are adequately represented. And in so many of these horror stories that we heard that are repulsive to all of us, the representation is simply horrific, almost non-existent. In the federal system, it's written into statute that anybody charged with the death penalty, with the death offense, is going to get they're going to have two attorneys, and they're going to have attorneys who are learned in death penalty cases, who have experience in death penalty cases. This is all done under the supervision of the federal judges, and I think I wouldn't say it's a perfect system, but I would say that you would have very, very few cases where, if any, in the federal system where you just have this utter breakdown in the representation and the right to counsel. I can tell you, in the defense attorneys that we've worked with on capital cases are very, very good at what they do. In most cases, it's the only thing they do. And they generally have all the resources they need to represent their clients very well. So when we focus on this report, I do think there are some aspects of the federal system that are worthy of review that might improve the quality of justice in Kentucky.
Thank you, Kerry. I had the great fortune of practicing a case once against Mr. Harvey, and it did not end well for me. I can tell you that. So when he speaks, I usually listen. And I can say that about the Secretary or anybody I'm speaking with today. Don't tell anybody about how that ended, Kerry. Really, don't do that. As I think about who I'm speaking with today, I've had the great pleasure of speaking with or working with, conspiring with, in the Secretary's case or my co-chair here, almost everyone. And so as I hear these opinions and thoughts, I'm struck by just how right everybody is, even if they're different in their opinions. And that's how emotional this issue can be. That's how guttural it can be. And so I'm also struck by whatever your position is on the death penalty, that we ought to get it right, whatever we do in state government, for that matter. And I certainly have heard those words from you before, and in the number of folks who've come to meet with me in my capacity, that we ought to take a look at the federal system. We ought to begin looking at these reforms. I have also had, Mr. Wine, a number of folks tell me of what they think is right about this report and what they think is wrong about it, or what they think has been misrepresented. So I've heard it all, the good, bad, and the ugly, Ed, and I can tell you that I've taken it all to heart. And we had an interim joint committee meeting, was it 2 years ago, where we focused on where Professor Ewald and a number of you here today, Justice here, and I think Professor Conley, you were on maybe, but I know I've spoken with you at a KBA convention on this, and a number of those on the team, maybe Mike Bowling as well, spoke and enlightened our committee, our both House and Senate interim joint committee on the topic. And we've also met behind closed doors any number of times on the finding, and I know my staff, and it is a small staff in judiciary. We have 4 lawyers and 3 support staff to handle roughly a quarter of the 1,000 or 1,500 bills that are filed every session, and my staff also gets to draft most of them. And so we're stretched to the end. And I can tell you though that every page of the report has been debated and reviewed. Whether it's the error rate or the inadequate pay, I'm also struck by what funding could mean to justice and to the administration of the death penalty in a just way. Whether it's Ed, again, the pay for public defenders, we know that we are far behind the curve with even surrounding states for pay, and that is a difficult issue right now. When the state is strapped for cash, revenues are coming in very slowly before this session. We know there'll be some additional budget cuts before this budget session, and so that's disturbing when we need money to pay people an adequate salary to do their jobs. So that in itself is a huge issue. I will tell you, though, that amidst some of the negative, I don't think I've chaired this committee, my Judiciary in the House committee, since 2009, and I've had the pleasure of serving with first now President Stivers in the Senate, who was there, and Tom Jensen, who is retired and on the bench now, and now my good friend and colleague, Senator Westerfield, who's from my hometown. And I think we've always worked very closely together. It's been an unusual relationship. I think many of you that work in and around the Capitol understand that I'm not just paying lip service to working together. We truly work together. In fact, we've been together all day working on a juvenile reform effort. He's laughing because the beard may be for another reason, but I think it's from the hours we put into this effort. We detain juveniles at an alarming rate in Kentucky, and I don't want to get off topic, but I use that. We also had the highest incarceration rate for adults, and it wasn't just the highest, it was almost quadruple the national average for the decade ending in 2010. We've reversed that trend. My point in telling you those things is, as a committee and as a body, I think leadership from our Judiciary Committee, we've not been afraid to tackle tough issues. We've not been afraid, Mr. Harvey, to tackle, and I could not agree with you more, I think this issue may move as the public allows it to move, because we've got 136 other legislators to convince that we may need to act on this if, in fact, action is necessary based on this report. You know, it's not just the two of us. We've got to convince some others. But there can be leadership from the committee, and there can be leadership from this group that I think, you know, gave of themselves and their time in a very unselfish way to give you this report. So I think leadership can come from those areas, and I think that's what it's going to take to move this issue through the General Assembly. I understand Senator Webb could not be here today, and I know she is. My understanding is she'll file a bill again. Is that right? And so we'll have that issue. You'll apologize. I'm dealing with a cold. My voice is shaky today. So I tell you that to let you know that we will give it serious consideration. We will meet, and we will meet again and again on this issue to see if we can figure out which recommendations could be placed into statute and could be used. And again, I can tell you, I don't, you know, it'll take the the funding issue will take some magic. I will tell you that. But we have saved millions in lowering our incarceration rate. We've lowered recidivism. We have begun to move money around in that area, but it is still slow before we see the real dollars. If we can close a facility in the near future, we can save millions that can be reinvested in the system, and I think could go to better pay for conflict counsel, better pay for public defenders, and I think that'll go a long way toward righting some of these wrongs. The other areas, again, could be done without money. They could be done with good policy and good thinking and the proper support in the House and the Senate. So I'm committed to doing my job, and that is to listen, be judicious with the issue itself. And if it gets to that point, I don't know, I'm sure there will be a bill in the Senate, and if it starts in the House, I'm certainly willing to listen as well there. So with that said, I'll turn it to my co-chair and good friend.
Thank you, Chairman. I appreciate it, and thank you all for having me. I've only been chairman of the Senate Judiciary Committee for 10.5 months, but I'll echo what he said in that we do see a lot of legislation, and Senator Webb's bill is certainly one of those things. And to her credit, she has advocated tirelessly with me to address some of these things, and I do have some concerns, and I'll get into those in just a second regarding the recommendations of the report, some of which I can see as no-duh sorts of things, and some of them not so much, at least not for me. Let me briefly, as an aside, completely unrelated, but since you mentioned it, I am very self-conscious of this, but it is No Shave November, and so I encourage you to donate to your favorite cancer charity or center, whatever you can this month, any month, but that's why I'm doing that and enduring this. You know, Coach Cal talked about Team No Sleep a couple of years ago. I am joining that team. I don't know what I can't sleep on that. Anyway, that's why I look the way that I do. I want to talk about some of the particular recommendations, and just so you have some background about me, I am a practicing attorney there in Hopkinsville, but before I came to the Senate this year, I was an assistant Commonwealth's attorney with Lynn Pryor's office there in Hopkinsville for a little over 5 years. I did not have the burden and the challenge of a capital case. In fact, that in my time there, I don't know that my boss did either. But I can say, looking back, had I gotten one, I would have prosecuted it without thinking twice. I believe, as the other prosecutors have said, the law is what it is, and I'm going to uphold it and pursue what I believe to be just results using it. As a legislator, obviously my perspective is quite a bit different. It's important to weigh what's going right, what's going wrong, listen, and hear what kind of things are going right and wrong. And this report brought a couple of things to my attention that I didn't know existed, and other things that, again, I don't agree with quite as much. For instance, the retention of evidence. I can't say that I was aware that was being destroyed or eliminated or I can't imagine it getting lost because I've had to deal with that before in cases that weren't even capital cases, obviously. So that's something that I think is a no-duh sort of fix. When it comes to resources for staff, I believe public defenders ought to be paid more. I believe prosecutors ought to be paid more. While we're at it, I think teachers ought to be paid more. I think social workers ought to be paid more. I think our staff back at the Capitol ought to be paid more. I can't think of any street-level state employee that doesn't need help in that regard. And from the defense side, certainly more resources to give conflict counsel or contract counsel. So no question the resources are needed there. I didn't have to get into office to realize that one vote isn't going to make that happen. If it could, there are a lot of things I'd fund that we aren't funding nearly as much as I wish we are right now. And I'd be moving money from one place to the next, but that's not ever going to happen. But I certainly agree with that. Talking about DNA evidence and biological evidence, I'll say that we did pass a measure just this year that allows for post-conviction DNA testing. There was a bill actually in both chambers, and I'm drawing a blank on who sponsored it in the House now. Johnny Bell and John Schickel in the Senate championed that bill. And I could tell you how that bill came about and came out as Representative Bell's bill, and it's going to sound like cheesy political talk, but I've never seen that the way that those two men approached who gets credit for what, who moves the bill forward. That both of us were in the room and we were talking about that bill and a number of other bills, because during the session obviously they're got to go through both chambers and both committees. And Senator Schickel didn't think twice. He said the bill's more important, and that went on through, and you just sort of wish you could see that on every single piece of legislation. But it did, and now that exists. So there are some additional protections there that we didn't have before. And again, that's a no-duh sort of thing. That's a of course sort of thing. Everybody in this panel would say that we need to do it right. We need to do it fairly. And that's a fix that I think was certainly without much controversy. Inconsistent and disproportionate charging decisions. I only know anecdotally the same stories that I'm sure many of the folks here on this panel and many folks of you all listening know, that you've got some prosecutors that do it one way and some prosecutors that don't do it that way. I don't know the best way to fix that other than at the ballot box. If your prosecutor's not doing what you think they ought to do, then maybe they shouldn't be your prosecutor anymore. Maybe you should run against them. Maybe you should fund their opponent's campaign. I don't know. I'm not sure how best to fix that. I'm not a prosecutor anymore, and certainly wasn't the elected when I was one. But I can understand how that does create some disparity, at least in how it's applied. And from a fiscal standpoint, it also creates a lot of cost. Mr. Monahan and I have talked about that, and we've discussed every time a capital case comes along, whether it's really reasonably called for or not, by practice, by ethics rules, there's an enormous amount of resources that are instantly engaged in that litigation that may arguably not be necessary because it's not the kind of case that another prosecutor may choose to make a capital case. The juror confusion, man, I wish I could fix that on every single set of jury instructions for every offense I have ever taken a trial. What a mess. With all due respect to the very learned minds who put jury instruction books together, that's just a mess. And I've never seen a set of jury instructions that I thought read succinctly and simply and plain English-y. And it's a nightmare.
Your mother would be proud of that.
Wouldn't she?
Yeah. His teacher mother would be proud.
I don't debate the need to overhaul jury instructions. I got to admit, maybe it's my inner prosecutor seeing the results of the juror poll that was in there. It made me think about the rule that says you're not. I think it's 10.6.4. You're not supposed to poll the jury to find an error of appealable or an issue of appealable error. And I don't know if that in the aggregate still applies, but anyway. There are a couple of these things, though, that the parts that I don't agree with, safeguards in certain ways and deficient counsel, I feel like there are protections for that. Maybe I'm wrong, and I'm certainly open to argument and interpretation on that, but that's what appellate review is for. Poor counsel, ineffective assistance of counsel, overreaching in any number of different places. The standards for law enforcement. You could make the argument that a written policy on identifications and eyewitnesses would be helpful, and I submit that probably would be helpful, but we've also got standards that are set by case law, set by other courts and other jurisdictions and other places, and that's what you apply. That's what you go by. And you make the best argument you can, and sometimes it favors you and sometimes it doesn't favor you. I don't know that we'll ever make it perfect. I don't know how to do that. But there are a lot of things that our justice system already provides. The fact that someone can sit on death row for 3 decades is proof of that. Is proof that there is an incredibly deep set of opportunities for appeal and review and multiple layers of review and redundant review and if for any case, certainly a capital case. And that you can find an errant judge somewhere or an errant prosecutor somewhere or a defense attorney or a police officer or an entire law enforcement agency. You're going to find those cases, but if we did everything that this report asked us to do, you're still going to find those. You're still going to have the outliers, the one-off sorts of situations where someone's just going to refuse to do it the way everyone else believes they ought to. So, at some point you have to draw the line and say we're just going to trust the system to do the best that it can do. I think there are places to improve, but I also think there are places where perhaps we're not taking advantage of what the system already offers. With that, I'll tell you the same thing that my co-chairman from the House has said. It is my fault and not Senator Webb's that we have not yet met. We spoke about it about 2 weeks ago following a committee meeting, and I do intend to speak with her about her bill and about what parts of it we might be able to move forward. I haven't seen any draft this year. I assume it'll be essentially the same bill that she filed last year that we did not hear. But I'm certainly open to hearing what we can do. And again, with that, I thank you all for letting me be a part of this very esteemed panel. I'm without question the greenest one up here, but I'm honored to have the opportunity and the responsibility that I have as chairman of the Senate Judiciary Committee. Thank you all.
Well, I really like the format of this panel because we were informed about 2 minutes before it started what the format was going to be, so we are all speaking off the cuff up here. Let me echo what Justice Keller said. A lot of people have asked me, well, how did they pick you all to be on this panel? What questions were you asked? The whole bit. I was asked if I wanted to join this panel. I really can't recall by whom. I was never asked whether I was for or against the death penalty. We never, in the any of our many meetings and telephone conferences, talked about that. No one asked that question, and I just thought I was joining up another one of those committees that you met every other month, ate lunch, fell asleep when a boring lecturer was there, and then you said, I'll see you in 2 months. And it wasn't that. It was the hardest working effort that I have been involved in. I didn't know Sarah could be such a taskmaster. Jim, when we started, or Professor Conley, I think you laid out a lot of things. But I found out that she could be. I also found out that she has tapped into that network that President Obama has that lets you listen to everyone's telephone conversations, because anytime she had a meeting scheduled and I was going to be out of town, she could figure out what state I was in, what beach I was close to, and I would end up, as my wife still reminds me, in a 2, 3, 4 hour teleconference on some interesting thing like preservation of DNA evidence. So it was a long, hard effort, and this was the best we can do, and we throw it out there for everyone to take a look at. I think it's probably all summed up to me. The question and the way our Chapter 1 overview starts out, the Commonwealth of Kentucky reenacted the death penalty in 1976. Between 1976 and 2011, there have been 82 capital offenses for which 78 defendants were sentenced to death in Kentucky. During the same time period, the Commonwealth executed 3 individuals, Harold McQueen in 1997. That was my first summer on the Supreme Court. I'll never forget that night. As long as I live, we were in the conference room, 7 of us, 6 men, 1 woman. It was the hardest night of my life. Father Delahanty was there with a line of about 10,000 people with candles lighted outside. I always give him a little grief about that, but that was our first one since the reenactment of the death penalty. Harold McQueen, Edward Lee Harper in 1999, Marco Allen Chapman in 2008. Both Harper and Chapman volunteered for execution, each foregoing his right to seek further review. 7 death row inmates died awaiting appeal of their convictions. State or federal courts have reversed the death sentence in 50 of the 82 capital cases as a result of serious error that occurred at trial. It sort of lays out what we have to address in a death penalty system if we're going to have one. And to be quite honest, even after 30 years on the bench, I hadn't thought about such things as the collection and preservation of evidence, or how it's kept. Are there any standards? Are there any guidelines? Are there rules or regulations or statutes? There are none. Crime laboratories, our state medical examiner. We have a renowned state medical examiner. She's a doctor. You don't have to be a doctor to be the medical examiner in Kentucky, nor do you have to be one to be a local coroner. Are there rules, regulations for any of that? Or identifications, eyewitness show-ups, all the things you see on TV? Do we have strict guidelines for how you do that? No, don't have that. Interrogations, how do you interrogate? When do you record? When is it videotaped? Do we have? No, don't have that. It's different everywhere. And the list goes on and on and on. But if you're there working in the system, sometimes you don't understand that. And so we're trying to figure out what's broken down, who's to blame here. And most of the time, when people want to lay blame on what's gone wrong with the death penalty system, it's usually the public defenders. You know, I remember arraigning I don't know how many people in criminal court, and when I'd say, do you have the funds to hire a private lawyer? No, Judge, I don't. Well, I'm appointing the public defender. Well, I don't want a public defender. I want a real lawyer. And I'd say that's why I'm appointing the public defender. Probably the only group, if you're looking at the people that the fingers are pointed at, public defenders and criminal defense lawyers, the prosecutors, and the judges, the ones with the most problems are probably the judges and the prosecutors. The public defenders, at least the DPA and our public defender's office in Jefferson County, they're the ones that have gone to specialized training. They're the one that adopted their own standards, modeling after uniform standards that a lot of people are required to have throughout the country. And I think back about all the training, judicial colleges that I've had in the last, or the 30 years I was on the bench. Luckily, I'm retired now. I don't remember ever having a specialty program on the death penalty. And I'm not sure what prosecutors go through, but I have a feeling that, you know, there are so many areas to cover, but none more important. And I think that probably the defense bar is far ahead of the rest of us in that. I know there have been some comments about why don't you all have a prosecutor on your committee? Why didn't you on this task force? We did. As a matter of fact, we had at least 2 people leave for various reasons the committee. So it wasn't for lack of trying to have a prosecutor on, whoever it was that came up with the names for the actual assessment team. But I can tell you that great efforts were made during the course of our development of what you see in this 500-page report to get input from the prosecutors of the Commonwealth. And it's all summed up under the executive summary talking about Chapter 6. If I'm on the right page here. The Kentucky assessment team was, as you go through these charts where we have in compliance, partially in compliance, not in compliance, insufficient information, a lot of times with the prosecutorial end of it, we've got insufficient information. And it's summed up this way. The Kentucky assessment team was unable to determine whether the Commonwealth complies with several of the recommendations in this chapter. The team submitted a survey to the Kentucky Prosecutors Advisory Council requesting that the survey be distributed to Kentucky's 57 elected Commonwealth attorneys. The survey requested general data regarding the death penalty in each prosecutor's jurisdiction, as well as information on training and qualification requirements of prosecutors who handle capital cases, funding and budget limitations, and capital charging and discovery practices. The council declined to provide information, stating that the council had voted, 1, to address the ABA study as the representative body of the Commonwealth's prosecutors, 2, not to circulate the study to the Commonwealth's prosecutors, and 3, not to provide responses to the survey questions. After receiving the response, the Kentucky assessment team addressed all further inquiries to the council, and subsequent efforts to obtain information from the council were unsuccessful. We tried to schedule meetings. We tried to get with prosecutors several times during the course of our gathering this information, and that's why we don't have a lot of input from the prosecutors as I wish we had had. You know, when you're trying a death penalty case, and anybody in here who's been involved with a death penalty case, I don't care whether you're the Commonwealth's attorney, whether you're the defender, whether you're the judge, you are consumed by a death penalty trial. It is incredible the amount of not only time and resources and money and court staff that are involved in taking a death penalty case forward. It's really hard to calculate how many cases, criminal and civil, are shoved back into the hallways in the corner and are not dealt with because you've got this death penalty case going on. It's a horrendous burden for everyone, prosecution, defense, the court, the clerks, the defendant, the victims. Everybody is just going through hell for quite a period of time, not to mention the families of all of those components. So it's unbelievable how difficult these things are to handle. And I think the purpose of this report is to try to bring some uniformity, to try to bring some amount of standardization to our processes, starting from the collection of the data to the final sentencing. And another shortcoming of the judges is looking at these reports on jury instructions. I mean, I was shocked, and I was shocked again today to, hear that number about the instructions in a death penalty case. And Jim, all I can say, when our expert who gave a great talk, and maybe we do need a linguist, I was wishing Bill Cooper was here to hear the review of Cooper's instructions that we have all, as lawyers, prosecutors, defense, have suffered through for years. And believe me, he's a good friend of mine and Jim's both, but instructions are difficult to write, they're difficult to understand, and I sure heard probably some of the most enlightening comments today from the expert from Indiana. And with that, I'll just say I appreciate what everybody up here has said, and we're here to talk to you all to try to have you all spread the word a little bit, because we did have a little momentum in the beginning, and it quickly came to a halt. If things aren't timed at the right time, as both of these senators know, by the time we got to talk to them, it was way too far in that first session after we got finished to have anything done. And then right around the corner comes another big controversy and problem for our legislators to handle, and these kind of issues sort of fade away. But that's why we're here. That's why we're asking for your all's help in disseminating the information that you've heard and try to get us on the right road to deal with a very difficult problem.
I'm going to go out of order real quick and offer my sincere apology on behalf of Chairman Tilley and I. He made a remark about our Juvenile Code Task Force work. We truly have been together throughout the entire day. And unfortunately, we both have to part ways with this wonderful company today, right now, actually, so we can get to another event, another meeting, to prepare actually for our last substantive meeting, not the last meeting, but the last substantive meeting of our Juvenile Code Task Force next Tuesday. I encourage you, all of you, please feel free to reach out to both of us. I know Senator Webb would invite you to do the same thing, and if you have access to the global list, I'm on it. If you go to the LRC website, we're both there, and you can find our email address. It comes to us. We get it. Please reach out to us, and I apologize. We both have to leave before it's over, but just wanted to thank you. Mr. Secretary.
He said you don't hear what he has to say.
Plus, I know what he's about to say.
Let me give you the disclaimer first. Much like my friend, the U.S. Attorney, I am appointed to this position. I took an oath to uphold the Constitution of the United States and the Constitution of Kentucky. Much like years ago, I took an oath to defend both of those constitutions. That being said, my first duty is to uphold the law of the Commonwealth of Kentucky. I don't write it. I don't interpret it. At times I'm asked my opinion on it, might even be asked that opinion in a few minutes, but I was at the United States Supreme Court in January of 2008 when the Bays case was argued. And if you ever have an opportunity, or if you haven't had the opportunity, I hope all of you sometime during your legal career lifetime get a chance to go to the Supreme Court and actually hear any case argued. It really is a fascinating experience. Coming out of the Bays case, you take away I took away certain things as realities. The first reality is that the United States Supreme Court at that time and since has never found any particular method of execution used in this country to be cruel and unusual punishment. That was the issue basically raised in the Bays case. The issue of whether or not capital punishment as a general constitutional rule had been settled back in 1976 and has not been disturbed. So what we had was, and I think what we have in this report, jumping ahead a little bit, is a situation where we have a constitutional reality and we struggle with a constitutional application of that reality. Truth is, and one thing that I would credit Professor Bright with is, the elephant in the room is really not some tortured discussion of how we go about applying this thing. In reality, if I was not the secretary, I'd say the discussion was, should we do it at all? But I will go back to the report for a minute. The report, right now in Kentucky, we are under a stay from Franklin Circuit Court. We can take no steps towards executing anybody, and we are not taking any steps toward executing anybody. However, on November 21st, 2008, and I think I may be able to say this with confidence, I might be the only one in this room who's actually presided over an actual execution. So on November 21st, 2008, it got more than constitutional, it got more than procedural, it certainly got more than conceptual. As I sat in a room with several different colored telephones, one in contact with the governor of the Commonwealth, one in contact with the Kentucky Supreme Court, one in contact with the death chamber at Eddyville. And as you know, I went through all the protocols, and the checklist was carried out as it should have been by the professionals in the Department of Corrections. And the governor was well aware of what his constitutional responsibility was. And this was sort of a test of, are you going to live up to your oath? And that night we did. But there was one moment of pause when we had reached a point in the proceeding, and I'm on the phone with the warden, and Mr. Chapman is in the room strapped to the table, and these words came across the phone. And the words were, "May we proceed?" And I, in a nanosecond, had to stop and think, well, who the hell is he talking to? Because, I'm the only one on the other end of this phone, and now I have to give an answer. And, you wonder, was this a rhetorical question or was this for real? Well, it was obviously for real. There was only one answer to give, but it still had to be given. That's the test of the oath. So I gave it. And then later on, I gave my report to the governor that, in fact, we had carried it out. He was a volunteer. Obviously, as you've heard, there's been only 3, and he was one who had volunteered. It didn't change the ultimate fact of the situation, that carrying out the laws of Kentucky, he walked into the room alive and we rolled him out dead. Some people don't like to accept that is, what it is. That's what it is, and sometimes that's what you have to do. It's much like going back to criminal law 101 when you try to describe to somebody the difference between legal guilt and factual guilt. I just smacked Martin in the face, and now we have a big discussion about, was that an assault, and we can talk about mens rea and intent and capability and culpability and whatnot, and a lot of students struggled with that, and that's why some don't even go into the area of criminal law, much less getting this deep. Going to the report, without necessarily, I view the report in large part as almost a blueprint of what criminal procedure ought to be in not just capital cases, but in most felony cases, because a lot of the recommendations that they talk about, whether it's the preservation of biological evidence, videotaping, safeguards against eyewitness testimony, at the beginning of a case, and I oversee the state police and corrections, so I get it on both ends. I mean, you don't know, starting out, whether this is a capital case or not. Sometimes you don't even know whether it's a homicide or not. You have a situation where you have an incident, you have someone who's arrested, maybe right at the scene, maybe not until a lot of evidence has been collected. And so these safeguards that the report talks about would have to have begun in almost any situation prior to the term that is determined to be by a grand jury enough aggravating factors to make it a capital case. So this is really almost a criminal procedure blueprint beyond capital cases, in my opinion. If I, as Secretary of Justice, were asked to implement, and by the way, it does cost a lot of money, and it would cost a lot of money to carry out everything that's recommended in here. Trust me. I know what is involved, where you would have to have cameras and tape recorders and the extra lab equipment and everything else that would be in place to meet these safeguards. That's not saying these safeguards aren't warranted. I'm just saying it's not free. It is not a stroke of the pen issue to get there. And that in Frankfurt becomes, reality as can you get there. Now, some of these things, obviously, I think in cases, clearly it's the way to go. And I think as Professor Bright talked about just this general issue, we may get there eventually. And we may get to where the point of all of the technological things that the report recommends, we will get there because they're becoming more commonplace in our society. It just hasn't, gotten all the way down to where all our police agencies, all our prosecutors have those abilities and capabilities at this particular moment in time. Let me turn to one other part that came out, not so much in the report, but it came out through some of the presenters. It's an issue which is sometimes called truth in sentencing. It's really not truth in sentencing as it is in our Kentucky statutes. It's transparency in sentencing. In that when jurors struggle with trying to assess the penalty, they're trying to figure out, okay, here's the range. Kentucky has this sort of mixed bag system where you can have a 2 to 10 sentence on a felony, but who determines where between the 2 and where between the 10 that's actually going to land? And the answer to that could lie in a lot of places. And that's what causes jurors trouble when they ask prosecutors, how long will this person get if we come back with a verdict of? And that's what you saw in some of these instructions here. So they manipulate verdicts trying to get to what they think might be a commensurate sentence with the crime if it's not death. And given the statistics that were presented today, there aren't many death sentences that are coming out in Kentucky. Certainly not since 2000 or so, or in recent years. So the truth in sentencing issue is something that could be addressed through a number of legislative means. I think we don't have enough. Frankly, I think our felonies are not, all due respect. I saw Professor Lawson around here a while ago. We've been on TV a lot about this. We have 4 classifications of felonies. Like Kansas has 11, Virginia has 6 or something like that. We have 4. I don't personally think they differentiate adequately between crimes against people and crimes against property. They certainly don't differentiate adequately into what our society has come down to now, vis-a-vis what drives our prison populations. So I think there can be some efforts made in this, whether you choose to call it truth in sentencing or transparency in sentencing. As far as the other safeguards, we can take steps for improving the safeguards, as I said, in the criminal procedure area. Ask me what my personal belief is.
What's your personal belief?
My personal belief, I was on the ethics committee for about 10 years. I don't want to go, get back up there as I can't call the hotline as I get ready to do this. But my personal belief is, given the way the report is written and the standards that they would seek in maybe just, in this case, capital cases, as far as all of the factors involved, the evidentiary collection, the instruction all the way down. In a capital case, I personally don't believe you can get there from here. I don't think that there will be enough safeguards to be able to put into place that you would ever meet all the standards set out here in the realistic world. And even your attempts to do would be challenged and challenged again, and probably rightly so. So that, you know, one has to wonder, are we going down the road of another effort on futility? And
I withdraw that question.
And, you know, I don't know that that's a wrong answer. I mean, I just think that that's, you know, you want realism in this thing, that's some of it. One question that did come out as I listened today, thank you for asking, is, with all due respect to federalism, and thinking of it from a constitutional perspective, we've been through periods in this country, historically and legally, where we've gone from the country being divided between slave states and free states, and then the country being divided between de jure states and de facto states. And it troubles me that now we're in a situation of the country being divided between life states and death states. If life is the most fundamental of our constitutional guarantees, then it strikes me, even with federalism being involved, you know, how does one face that ultimate deprivation across some dotted line on a map and not some other place? But that's something for somebody a whole lot, for you constitutional and new constitutional scholars out there to, you know, to debate. Going back to the disclaimer, I'm the Secretary of Justice of the Commonwealth of Kentucky. Along with my Governor Steve Beshear, we took an oath to uphold the laws of the Commonwealth, and we have done that to the extreme, and we'll continue to do so until our terms are up. Thank you. He's going over there.
I'm glad our secretary is taking care of his oath. Nobody said you couldn't have any opinions, because you certainly do.
You know, they tweet all this stuff nowadays. So I may not have a job, but I'm not get out of here.
Don't worry about that, Michael. There's always a job for you. I'm a member, outgoing president actually, of the Kentucky Association of Criminal Defense Lawyers, and as you can imagine, our organization fully supports the ABA recommendations and the moratorium suggested for the imposition of the death penalty in this state, the moratorium against the imposition. We agree with the recommendations in the report, and that may be obvious as criminal defense attorneys, but let me talk just for a little bit where I come from in terms of getting into being on this panel. After graduating law school, I served 5 years as an assistant Commonwealth's attorney in Jefferson County. I was there with Tom Wine, and really enjoyed that job. One of the things I did on that job, I participated in 3 capital prosecutions and had 3 death penalty verdicts in the 3 cases that I tried. Since that time, I've defended a whole lot more death penalty cases than I tried as a prosecutor. And I think over this period of time, if the 80s or the old days, I've seen the evolution of, at least in the trial courts, how these cases are tried from the lawyer standpoint, maybe a little bit from the judge's standpoint, what the judges have to put up with, what the lawyers have to deal with. Not uncommon. I mean, I did it. Have one person defending a death penalty case. I mean, it sounds totally crazy today. I don't know how many of those I did. And with a trial judge saying, Larry, we're coming back on Saturday. I know we started on Monday. We'll come back. We'll finish this thing off on Saturday because I got a big docket next week. So that's a lot of fun. Come in on a Saturday, start the penalty phase. And in one particular case, not to get too anecdotal, my client's down in the jail had been hoarding his medication and had taken a whole bunch of pills trying to kill himself that night. So I come up to court to start the penalty phase, and I said, Judge, I'd like a continuance because my client's trying to kill himself, not just this jury. Well, we went forward with the penalty phase, notwithstanding the fact that I was able to get a hold of a psychiatrist on Saturday morning at 9 o'clock, come talk to my client, come see my client, and judge just kind of discounted his opinion that he may not be competent to go to trial. So I've seen things evolve. So now you have two counsel. You usually have a mitigation specialist. Things are a lot better in terms of the representation, just from the standards that are in place and the things that are expected of the lawyers in the case. And I think the prosecutors in the cases, these types of cases, are a lot more sophisticated. They're better lawyers, and they try a better case. Notwithstanding that, maybe because of the anecdotal things that I've seen in my time in practice and some of the people I've represented, that's why I would agree with these recommendations in that we should put a halt to any kind of death penalty imposition in this state or any other state unless and until all of these things that are recommended are implemented. And maybe not even then, but I'll get to that later. Even though I'm going to tell you a couple of things about clients of mine that are anecdotal, but they reflect what is been going on, been coming up and being shown in this country and in Canada for the last 15 years or so. Hundreds of exonerations, usually by forensic evidence, but also through other means. We've seen that hundreds of people, not all of whom have been on death row, but hundreds of people have been found to be 100% completely innocent long after their appeals are exhausted, long after their petitions for habeas corpus have been gone up in smoke, not through the court process, but through other processes, through the investigation of other people, innocence projects nationally in all the states. Linda Smith is here. She's with the DPA Innocence Project. She represented on the post-conviction motion a client of mine, Edwin Chandler, who was convicted in Louisville actually was convicted of manslaughter and robbery in the first degree. It was a capital prosecution, but either the jury compromised or whatever on his verdict, and he was sentenced to a long prison sentence. He served 8 years. After he served 8 years, he was on parole for 8 years until the Innocence Project represented him and got his conviction thrown out due to a wrongful coerced confession. And in Mr. Chandler's case, the lead police detective on the case said Mr. Chandler came into the police. He found that the police were looking for him for this robbery murder, voluntarily came into the police station without counsel, sat down, waived his rights, and started talking to the detective. Detective said after Mr. Chandler told him, I have nothing to do with this. Here's my alibi. I was with my girlfriend, a couple other witnesses watching television. Here's their names. You can get in touch with them. Police officer said, will you take a polygraph test? And Mr. Chandler said, sure, I'll take a polygraph test. After being told that he had flunked the test, the police officer at that point in the interrogation, it was not recorded, it was not videotaped, started telling Mr. Chandler, you've told us that you've been staying with your sister who has 2 young children. Unless you confess to this crime, we're going to lock her up for harboring a fugitive, notwithstanding the fact that Kentucky law would prohibit that person, a family member, from being prosecuted for harboring a fugitive. Notwithstanding that fact, also told my client that they would put her 2 kids in foster care after they locked his sister up. At that point, Mr. Chandler felt he didn't have any choice, and he gave back a lot of the details that the detective gave to him. And that was the thing, and that coerced false confession led to his conviction. And his service in the penitentiary and his service on parole until, as I said, the Kentucky Innocence Project worked with a detective with the Louisville Metro Police, Denny Butler, that secured, after a long search, forensic evidence, a fingerprint that came back after a computer search that was not available back in the 90s when he was convicted, and found the person that left the fingerprint who was the shooter and the murderer in that case, and that person is currently indicted. That didn't happen on an appeals process, ladies and gentlemen. Let me tell you secondly and briefly about another client of mine. William Gregory was the first person exonerated in Kentucky by DNA evidence. Mr. Gregory was convicted and given like an 80-year sentence for breaking into apartment buildings and sexually assaulting 2 women. Mr. Gregory, when he went to trial, there was a examiner, a hair examiner from the Kentucky State Crime Lab came up, testified at his trial that she had done a microscopic, eyeballed it under a microscope, examination of hair fragments that were found at the scene of one of these break-ins that could have only come from the perpetrator. Her testimony to the jury and her very professional testimony to the jury was, those suspect hairs and the hairs of Mr. Gregory are 100% match of 22 different factors. And they match 100%. And you know what, ladies and gentlemen? I've never seen so many matching characteristics in a hair analysis in the 20 years I've been doing hair analysis. And I can tell you this, I've talked to Mr. Gregory on many occasions. And I asked him, William, well, what'd that feel like, sitting there in trial, sitting there listening to that testimony? And what William told me was this. This trial took about 4 days. William's sitting, and during this trial, they're doing jury selection, opening statements, they're putting on evidence, et cetera, some identification evidence, and cross-examination. His attorney's doing a good job, and the jury's there taking notes. This lady from the State Police Crime Lab gets up, starts telling about the jury about her hair analysis. Jury's put down their pen and paper. Sat like that the rest of the trial. Can you imagine if you're innocent and you hear testimony like that? Jury wouldn't look at him the rest of their trial. He had about 2 more days left to trial. He had to sit through that. Then obviously he was convicted. With the Innocence Project in New York, there was a motion for a new trial, and I was fortunate enough to be asked to assist them in Mr. Gregory's case. And we convinced the trial court to give us 1 hair fragment, and at that time, Mr. Gregory and his supporters had to raise the money, about the $5,000 it cost to test DNA analysis, this mitochondrial hair analysis. And that came back, and that test result excluded Mr. Gregory. And with the assistance of David Stengel, as the Commonwealth attorney in Jefferson County at that time, Mr. Stengel agreed after that first test that they would go ahead and test all the other hairs at state expense. And guess what? Every single one of those hair fragments excluded Mr. Gregory as the donor, and eventually his case was dismissed. His conviction was vacated, and Mr. Gregory's case was dismissed. And I tell you about those 2 things, 2 cases, to say they happened to real people. They could have been death penalty cases, and the appeals did them no good. Okay? It was people that worked for the Innocence Project that dug and they got forensic evidence out long after the fact, and they were able to get those convictions set aside. So we all know about faulty identification witness evidence contributing to this, and snitch testimony contributing to false convictions and wrongful convictions. But you also had forensic evidence, either examiners or misplacing evidence, and you also have police misconduct. I don't know if these reforms that are being recommended are going to correct the misconduct. I can give you one little piece of my mind that in general, I would say that if the police want to hide exculpatory evidence and they're going to coerce a confession, they're obviously not going to tell the judge that. They're not going to tell the jury that. They're not going to tell the defense attorney that. And they're not going to tell the prosecutor that either. So if nobody knows that this police misconduct's going on unless it's the police, and the police are going to willingly lie on the witness stand about their investigation, then none of these reforms are going to make any difference. So to boil it all down, if you want to synthesize Professor Bright's talk to us, which was wonderful, and I enjoyed hearing that, and I think all of us did, if you want to boil it down to it, the process that could result in a death penalty to anybody in this state or any state that has a death penalty, it depends on people. It depends on people doing their job and being 100% honest. If you can't guarantee that everybody in the process is 100% honest or is 100% committed to doing their job, then the system really isn't going to work. And those are problems that exist today, and those are problems that are going to exist in the future. That's my 2 cents.
I never said there wouldn't be some expense in these recommendations, but there's some recommendations that are expense-free. Right. The change in a jury instruction, that's free. The change in eyewitness identification, that's free. Guidelines that guide the discretion of prosecutors, that's free.
Can you guys hear me with us? Okay. I can use this if it works, but so in the back you can still hear. Okay. I'm sorry that our legislator panelists had to leave a little bit early because I think a lot of the questions that some of us might have had might have been best directed toward them. I wanted to go ahead and open up the floor to questions because I assume there might be a lot. If there's not, I do have some follow-up questions, but I would like to give you all the opportunity to ask our very esteemed panelists any questions that you might have. So, yes. And we have... Okay, I'll repeat your question so that everyone can hear it.
I think most of you know me. I'm Pat Callahan, chair of the Kentucky Coalition to Abolish the Death Penalty. I just say that for transparency purposes, you know where I'm coming from. The question I have comes under the notion, I'm just looking for reactions. I am sorry, I think this might apply to them in a sense more, but Representative Tilley has brought up cost. Someone referred to Senator now Judge Jensen, who was willing to give a hearing to talking about the study and saying that, he supports the death penalty, but he said it's going to cost so much to fix this, we probably can't use it anymore, so we may as well just live with life without parole. My question comes under what I consider the notion of a value of a justice system, that it must, one of the primary values in the justice system is it's got to have credibility and consistency, and given what we've heard, it strikes me that with the lack of funding that Representative Tilley admits we had to correct some of the findings that are here, if we agree that some of these findings are accurate, we may disagree about some of them, but if we agree that some of them are egregious and accurate and can't be funded at this time, doesn't it make sense to do what Mr. Simon was talking about in terms of a moratorium? And are people willing to press for that until we can look at it, and so that we don't keep pushing a system that we know doesn't have fairness, accuracy, and credibility? And the other issue related to credibility for me is that assuming that the death penalty has some public purpose, whether it's deterrence, safety of people, closure for victims, whatever the value is that people want to hold on to this public policy, when it's not administered across the state in what Senator Westerfield called the system. Dave did it one way, you're doing it another. Ray Larson does it a way. A lot of people can't even afford to prosecute a death case in their counties. We don't have a system. So how does that strike victims where their loved one is killed, prosecutor never seeks death? What credibility does that give them? Or if closure's the value, where does that come from? So I'm just interested in reactions to, in terms of the value of the credibility of the justice system, how does some of this all tie together?
Could everyone hear the question? Yes. Okay. Great.
Or danger, too.
Where's the microphone?
I don't think you can put a dollar sign on what the Constitution requires.
Well, I think that you make a good point, and if the legislature's response is we can't afford to do this right now, doesn't that lend credibility to your position that, well, if we don't have the money right now, isn't that a great argument for going ahead with this moratorium until we can have gaming?
Yeah.
My name is Roberta Harding, and I'm a professor here at the law school. My office is next to yours. And this is an individual who's still in that appeals process. That was mentioned. Where somebody might get away if you're wrong, if you're not guilty. That wasn't even done. And the prosecutor was furious that we stopped looking for someone that night. This is not 1960 or 1970 or 1980. She's not, 21st century. I understand it comes from that. But I also think, the few death sentences that we have, and we have life without parole, what does that do? In terms of purposes, people feel overwhelming themselves if we're having death qualified juries, which are not representative of the entire state. People feel that life without parole is sufficient. It's sufficient to serve general terms, incapacitation, and retribution. So that's, all these little points. The notion of cost, given a constitutional right that belongs to all of us, if we're accused of committing and tried a capital theft, seems to be ignoring, I don't know, maybe the essence of justice is implied in the Constitution. I know I would not want to be tried and told, oh, well, we can't do this. Yes, hyper liability outcome. But it's too much money. Oh, you'll get your relief later. Excuse me. I think you need to fund that this trial attorney is supposed to be. I'm not saying others, but maybe you can get my trial attorney. Greg Wilson appeals have not worked for him. It's still on death row. And that is a travesty. Paul Bar, constantly being aware. That's a travesty. I hope whoever governor is, with his execution warrant signed, will have the passion to understand high reliability and the outcome of the amendment right was denied, and will continue to sentence like that fall. So I'm going to read this question. Money, high reliability, 8th Amendment.
Anyone want to take that? Okay. Yeah.
All right.
We'll take questions. Skip the speech.
And I'm going to repeat the question just so that everyone can hear it. Does a circuit court judge in Kentucky have the right to disqualify themselves on a capital case based on their belief system, or by taking the oath of office, do they have to impose a capital sentence or be willing to impose a capital sentence in a case?
I never did have that problem, so.
I don't think it matters what the issue is. If a judge feels like he has a bias, he should disqualify. The difficulty is, though, I would suspect, is that if you have a conscientious judge who feels like there are problems with the imposition of the death penalty and disqualifies, just like we go through the jury selection process of individual voir dire, and you get everybody off the panel who says, I can't impose it, and all that you have left are people who say, I'll think about it or I will impose it, then you're going to slant the system. And I see that as a problem. And I don't know if I could even begin to answer all the questions that were previously asked by the professor, but, and again, I guess it's the individual. I'm somewhat of a pack rat, and thank goodness my predecessor was as well. We have more stuff saved from prior cases that may never, ever be used. In fact, behind our building, there's an old boiler room, and Jefferson County that stuff is getting stacked up in because we don't want to throw anything away. And we recently re-prosecuted a arson case, and thank goodness we didn't. We saved everything and got a conviction the first time, got a conviction the second time. So as I said, there's a lot, and I guess I should also say this, the same disclaimer as the Secretary. I don't speak for the PAC, Prosecutors Advisory Council, or the Commonwealth Attorneys Association. Probably if I did, I wouldn't be here. But I think that, again, a lot of the suggestions, as Professor Connolly has said, are ones that can be implemented with little or no cost. Accreditation of labs, that's not an issue. We are fortunate to have a DPA and a public defender's office in Jefferson County, DPA in the state, that do follow the standards set by the ABA. It's expensive to them, but it's the right thing to do. We do record all confessions in Jefferson County on all cases. And I found it somewhat disingenuous and was shot down when I said, I don't understand it when a prosecutor or police department says we don't have the money for the equipment when their kid has a $300 smartphone, thank you, you're lifting yours up, has a $300 cell phone that can record for hours information and does a beautiful picture, So I don't understand that, and I think it's there for us that we could make the system work better.
Roberta, I'm going to answer your question, I think. It's about cost. I'm old enough, I'm the oldest one up here, that I can remember when we didn't have the public defenders. And our Supreme Court come down and said, oh, enough's enough. We're going to have them. It's going to have to happen. Well, that's like this things that we've recommended in this report. We would not think today, the Bar Association, the voters, they'd be up if we were going to take people to court and try them without attorneys today. Well, we've got some safeguards that needs to be put into the system, more safeguards. And so I always get uncomfortable when you start talking about cost of due process or cost of upholding the Constitution or, what does it cost? One drone?
Yes.
I'd like to ask the panel sort of a more global question. Steve told us that Justice White said one of the problems with the death penalty in 72 in Furman was arbitrariness, like lightning strikes. Our death penalty passed in December of 76. We have about 60 to 90 people death eligible every year out of our about 250 homicides. If you take 60 and you multiply it times 37, that means we've had well over 2,000 people death eligible since 1976. We've executed one person out of over 2,000 people. Every year we have 60 to 90 people death eligible. We are now finding and sentencing people to death under one a year. The death penalty is allegedly for the worst of the world. So my question is, at what point, one out of over 2,000, less than one in 60 to 90, at what point are we exactly where we were with Furman, where it's like lightning again?
I assume everyone in the back could hear that question. Okay.
I'm not exactly sure I understand what he's asking.
Does anyone want to respond to that?
Was that a rhetorical question?
We have 9 people in Washington that will tell us when we get to that point. That's the system that we have. That's how James Madison envisioned it. We'd have 9 people in Washington that will make that decision. And I'll just make an observation. I think, how many people, let me just ask, how many people in this room are undecided about whether you think the death penalty is a good thing or a bad thing? There's not a lot of persuadables in here, and we could have a different presentation, in a different crowd and hear example after example of the crimes that lead to the death penalty, and you wouldn't have many persuadables in that crowd either. The only observation I would make about this report is I do think there are very important issues raised by this report. I think this is great work. I think these are recommendations that should be seriously studied and seriously considered, and in many cases implemented by our state policymakers. But all of these recommendations don't address the argument about whether we ought to have the death penalty or not. They address how to take existing law and make it work better and do more justice. But I would just suggest to you that for the people who are going to champion this report, that if you conflate the suggestions in this report with opposition to the death penalty, you won't get very far in Frankfurt. You will defeat what you're trying to accomplish. Now, I'm not suggesting that you shouldn't argue against the death penalty if you're against it, or for the death penalty if you're for it. And I can tell you, if Congress abolishes the federal death penalty tomorrow, there will be no lamentations from me. I'd be fine with that. But I'm just suggesting that when you take this report forward, if it is seen as an anti-death penalty movement as opposed to a pro-justice movement, it just won't get very far over there. I've been to Frankfurt. I think I'm probably right about that.
You're right.
I have a question for the panel, and that is that the law in Kentucky mandates the gathering of data on capital cases, yet we've done a horrible job in the state of collecting. You can't find it. And the reason I ask this question is I recently consulted with Professor Vito, and he said we don't have all the data, but the law says we're supposed to gather it. One suggestion that I think, I'm curious if anybody opposes this on the panel, is if we could determine the number of death eligible cases that come in, the data in those cases, so that we can gather those centrally to examine the death penalty without a bias from either side, to see the factors of race played out clearly, to see the income level of people in the cases clearly, to see the victims, the jurisdictions that these things originate from, and maybe that's the expense of creating a new form that the state of Tennessee already does a form for their entire state capital system, which they don't use and don't have a law requiring them to use. We have a law, but we don't have anything to report. And I'm curious what the panel's thought would be if we could collect this data and perhaps give that to people like Professor Vito, who would know what to do with it, or the ABA, to examine real-world, real-time evidence about how the death penalty is applied in Kentucky.
Well, you're right. One of the things we found in doing our assessment is we didn't have the data, and we couldn't get the data. And the only way to get the data would be go to county by county and count the number of death-eligible indictments that came down, essentially. We call for a statewide database to collect the information that you need to do a proportionality review, but you're right, we don't have it.
Is there any opposition to that from the panel?
The administrative office of the courts, I think, is the best place to start, because every case that gets indicted, every case that gets charged for that matter, that information goes in, and then you can see which ones you have the aggravators filed with as well, and homicides that qualified, and then see what happens to them afterwards. But it's all dependent upon people putting that information into the system correctly. And I tell you what's interesting, and part of the reason, I guess, is as long as we have independently elected judges and independently elected prosecutors and that all, there's no uniformity in that process. And it's most frustrating to the general public. Somebody will call me up and say, you need to do something about the county attorney in Jefferson County. Well, I have no supervisory authority over the county attorney. Well, you're higher than he is. Well, I have no supervisory authority. As a judge on the Court of Appeals, I'd get calls complaining about a judge somewhere out in the state Well, you're on the Court of Appeals. You should be able to handle that. That's not the way the process works. Cases, and I'll give you a good example of why I think sometimes the information with AOC, unless the Supreme Court Justice, Chief Justice makes it more mandatory to follow through with that, cases that are waived from district court to circuit court via the grand jury, in Jefferson County, every one of those cases that are waived, we present to the grand jury, and either there's an indictment or there's no true bill. Out in the state, if a prosecutor doesn't want to fool with it, he just puts it off to one side, and that case never comes back up again. So you have an individual whose case was waived from district court to circuit court, and all it shows is waived to the grand jury, and 5 years later, every time he tries to get a job, it says, well, you got a pending charge here, and he can't get the Commonwealth attorney to present the case because the Commonwealth attorney says, there's no rule that requires me to do that. And there is a rule, in my opinion, that makes it very clear that you're responsible once those are waived over. But so every prosecutor does that different. And if that's how they're handling that information, then that information is going to independently elected clerks who enter that information. All that because there's no real, with all due respect to the powers to be, there's no real oversight throughout an entire system, except when the Supreme Court rules on a case and says you tried it wrong and sends it back again.
Well, I'm not exactly sure what the question was, but we did recommend that we basically go to something like the federal system where individual U.S. attorneys don't make that decision. We recommended that there be guidelines established by the Attorney General in consultation with experts on capital punishment, including prosecutors, defense attorneys, and judges, in order to ensure that each decision to seek the death penalty occurs within that framework. So each Commonwealth Attorney's Office would have to set up a set of guidelines. Those would have to be approved by the Attorney General's office, and before a case went forward as a death penalty case, it would have to be approved by the Attorney General of the Commonwealth. Right now, as you know, each Commonwealth's attorney has the sole discretion to decide whether to go forward or not. And I was in one of those terrible situations, which I understand has happened, Jim, in a couple other counties, where the Commonwealth's attorney that was in office during my last several years on the circuit bench, if a case was death eligible, it was tried as a death penalty case. So the last 3 death penalty cases that I tried, not only did the Commonwealth's attorney not get the death penalty, all 3 defendants were acquitted in each trial. So we went through months and months on each trial to get ready, to go through all, and because he thought it was part of his oath that if they're death eligible, they're going to be tried that way, that's the way he tried them. And every good prosecutor knows that, I heard, Jim, one of our old prosecutors, Ed Schroring, probably the smartest, maybe the only thing smart Ed ever said, but you got to have the right defendant, you got to have the right victim, and you got to have the right facts. You got to use some prosecutorial discretion. And we have prosecutors still in Kentucky that don't use any discretion. That's using no discretion. God only knows what it costs, not only in financial resources, but every other way. But, that is one of our recommendations, and I think that would go a long way in bringing some uniformity to prosecution of those kind of cases in Kentucky. Well, and let me say this, because we were all very concerned about that, and really surprised about that they didn't want to have some input. And I don't know how many different times we tried to get just then face-to-face meetings if they don't want to do these surveys or whatever. But no, we're making this decision on behalf of all prosecutors throughout the Commonwealth. Right before we were getting ready to issue our report, I happen to be very close friends with Jack Conway, the Attorney General, who's sort of my unofficial godson, and I wanted to have a meeting with the Attorney General to let him know that when our press release came out, somewhere in there was going to be this criticism, or at least this factual explanation of why we didn't have input from the prosecutors. I wanted Jack to know that before it hit the street and hit the press. And 2 or 3 days before that, I called up our Commonwealth's attorney that preceded Tom, and I called up our county attorney. And I asked both of them if they had gotten a copy of the surveys, or, why did they vote not to cooperate. And they said, we don't know what you're talking about. Nobody ever called the Commonwealth attorney in Jefferson County or the county attorney in Jefferson County. So I don't know exactly what level, who made that final decision, but I have a feeling a lot of prosecutors throughout Kentucky were very upset when they saw, they were being painted along with all the rest of the prosecutors and not cooperating. You've been involved with state prosecutors a lot more than me. I can't understand that or explain it, but just either a lack of communication or worse.
Yes.
This question is for you and Kenyatta. Follow the last one. When Senator Westerfield was here, he said there are some well-done parts of the bill that obviously he can support. You said that there's many parts of the bill you can support. One of the things that I've seen with criminal law bills is what we just talked about happens. The prosecutors don't participate in the development stage, and then when it's in committee, all of a sudden they appear and raise 50 objections to it. I came from broad brush, but I've seen that over and over again. Is there any part of this assessment, and I understand you're not here on behalf of prosecutors, but as the Kenyatta representative, is there any part of this assessment that you believe prosecutors would affirmatively support in legislation and participate in the development of that bill?
Well, let me emphasize again, number one, I do not speak for the Prosecutors Advisory Council. And number two, because the Prosecutors Advisory Council decides my budget, I probably am not going to speak against the Prosecutors Advisory Council. However, I did speak for the last session on Senator Schickel's bill for expanding post-conviction DNA testing for non-death penalty cases, because I believe that, again, to be the appropriate thing to do. If you have evidence that would exonerate a person, I don't care that they aren't facing a death penalty, even a 10-year sentence or a 5-year sentence to be deprived of your liberty for that amount of time, I think is wrong. And so I spoke in favor of that, and there were prosecutors who felt that I shouldn't do that. So I don't know that you're going to get uniformity again unless the Prosecutors Advisory Council, which is basically the Attorney General, 3 Commonwealth attorneys, 3 county attorneys, and 3 citizens who sit there and vote. Because at the time that this study was being done and they were being asked to participate I was still in the Kentucky Court of Appeals, so I had no connection with it whatsoever. But it sounds like, based upon what Justice Johnstone said, that there was a decision made that perhaps was not voted on by all the prosecutors here in the Commonwealth of Kentucky. But that's the way the Prosecutors Advisory Council is set up by statute, is that they're supposed to represent the interests. But personally, I think if you're going to represent somebody, you got to know what they think. And the easiest way is to send out an email. It's not like we're in horse and carriage days. You can send out an email very quickly and say, or do you want to participate in this study? And here's what might happen, what might not happen, and let the prosecutors vote on it. I know we hear that all the time. Just bring it to a vote. Don't let the leadership decide it, whether in Washington or Frankfurt or perhaps the Prosecutors Advisory Council. But I can't tell you as a group what they would or would not support. I'm sorry, I can't.
Do you have any other questions? Well, I want to thank you all and thank all of our panelists and all of the speakers that we've had today. I think this has been a tremendous conversation. And we hope that it's the beginning of a conversation that will continue to proceed forward at this point. So thank you all for coming.
See you, buddy.